I've received a letter from the association. The matter is, the first appeal is pending. A certain amount of electricity amount is due. And if it is not cleared, the electricity of my showroom will be disconnected. But the first appeal is already pending. Lordship, before Honorable High Court.
You are the appellant.
Lordship, I'm for the respondent, opposite party
Who
respondent.
is your other side?
Lordship, I'll be serving in course of today, Lordship.
No, serve and mention tomorrow. Give a notice and mention tomorrow. Tomorrow is the mentioning date.
Lordship.
Yes.
Wait.
Give a notice to your friend, other side.
Lordship.
Item 1 কি ঘন্টা হবে না?
Are one.
Item 2. Well, I am for the petitioner.
The state response.
Well, this is my service. দিয়ে দিচ্ছি এটা। May I read your lordship? On 22nd of March, 21st of March, 2023, the minor daughter, along with his wife, along with the wife of the petitioner, was abducted by the private respondent while they are returning from the market.
Do you have any matrimonial dispute?
Lord, no, my lord, there is no matrimonial dispute.
Then you lodged a complaint.
Yes, complaint my lord lodged on 25th of March, that is page 21.
By you.
Yes,
What is page 20?
my lord.
Page 21 is the typed copy.
Yes, type of,
Very good. But thereafter, nothing happened.
no.
Then you wrote to
My
the.
lord, petitioner learned that
They
they were-
registered a case. They registered a
case
case.
registered. But petitioner learned that they are hidden in a hidden place. They are kept in a hidden place by some immoral act.
But have you served notice upon the other side?
Yes.
Respondents. All the respondents have.
Yes. This is my previous service.
Lordship, there is an existence of an extramarital relationship in this particular case. The principal accused is absconding. The father of the principal accused have been arrested, and presently the driver who was involved while taking that particular lady with that person, he has also been arrested. He is being interrogated presently. He's an
The
officer.
person with whom she was having allegedly extramarital relationship.
The father of the principal accused with whom she is.
Principal accused is the person with
Yes.
whom she had an allegedly and
Yes, ma'am.
Is
how
there
did
any
you ascertain
statement?
that?
Lordship, because we have got a phone number where from we have got that there was continuous calls in this particular number, and we have also interrogated the father of the principal accused, who has stated to us that there is an existence of
Who
relationship.
is that person?
Lordship, he is namely
Respondent number 5.
Yakub Bishas, the private respondent number 6.
And
Father.
Israel has been arrested.
No, my lord. Israel is the principal accused.
Israel is the principal.
Yes, my lord. And
Not
another
Yakub
person,
Bishas.
Hmm.
Achha. Now
another person,
Israel's father was arrested.
yes, ma'am.
He is not here. Ibrahim. Now
No, Yakub.
Yakub,
Yakub is the
father.
father of
Israel.
Oh,
Israel.
oh achha.
And
And who is Ibrahim?
Lordship,
Father.
he is the
Brother.
brother of the principal.
Now this Israel is married.
No. He's not married.
Well, let them, my lord, produce before the court. If they have, my lord, any, there are any relations. Yes.
And moreover, Lordship, the driver who was involved in taking that particular lady with it, he has also been arrested. His name is Rohit Ali. He has been arrested and he is presently in custody.
You have not yet, you could not ascertain the place.
So, Lordship, we have got 6 phone numbers which we are analyzing. We are coming. The investigation is continuing. We are confident that we can get a trace of her.
Minor daughter also there.
Yes, minor daughter is there.
What is the name of the driver?
Rohit Ali,
Now he's still in custody.
my lord.
And the father has been
Fa-
granted bail.
No, he is also in judicial custody.
So Yakub and driver is
Is in custody, my lord.
Rohit.
Yes, ma'am. Lordship, the difficult
রিকভার কর বললাম
আসো। তাহলে অ্যাডভোকেট Mr. Mukherjee learned advocate appearing for the petitioner submits that the petitioner's wife, namely Nomonita Das, Ekete Haldar, went missing along with her minor daughter, namely Aheli Haldar.
আহেলি
Aheli Haldar, who is aged about 6 years, on and from 21st of March 2023. Stop. Immediately a complaint was lodged before the Tehotto police station,
ইয়েস
but till date, the authorities have not been able to recover the petitioner's wife and daughter. Aggrieved thereby, the petitioner has approached this court. Upore affidavit of service filed by the petitioner be kept on record. Stop. No one appears on behalf of the private respondents. No one appears today on behalf of the private respondents. Stop. Mr. Kobi, learned advocate appearing for the state, submits that on the basis of the petitioner's complaint, Tehotto police station case number 234/2023 dated 25th of March 23 under section 363, 365, 34 of IPC was registered. Stop. In course of investigation and upon analyzing the call details, it was ascertained that the petitioner's wife registered. Stop. In course of investigation, the private respondent number 6 and
another person, namely
one Rohit
Ali.
Ali had already been arrested and they are in custody.
My lord.
The authorities are making a sincere and investigation is still continuing, and the authorities are making a sincere endeavor to recover the petitioner's wife and child. Stop. In view thereof, is the matter for further consideration on 7th June. Stop. The investigating officer shall file a report on the returnable date as regards the status of the investigation. So, COVID যেটা বলেছো, let the documents as produced, be kept on record.
After that is grateful. Lordship.
Lord, can it be at 2 p.m., my lord?
After vacation also you are busy, Mr. Mukherjee.
No, my lord.
You have drawn up your calendar.
Lord, 16th of March, that June, that is why, Lord, I have a matter that is
You need to be here.
As you
Hopefully your wife will be recovered by then.
as your lords.
Grateful.
Name of the passport there.
Well, I am appearing for the defendant appellant matter before your lordship matter. Your lordship directed me to serve. Well, I have served matter, but
The address would not be located. Would not be located.
well, the address matter which is reflected in the cost title, I have served on that address only. Well, this is a suit for partition matter. Well, preliminary decree has been passed.
You are the plaintiff.
I am the-
Respondent has been served.
Yes, the plaintiff matter has filed a suit. Well, he has obtained a decree.
He has been served.
Well, he is well only one party. Well, because he has no,
We understand that.
yes, yes, address, no, he
Is
has
your
not.
service upon the plaintiff complete?
No.
He has not received.
Lordship will kindly see addressee not found.
This plaintiff, Ravi
Yes.
Sarkar.
Yes, yes.
This cannot be located.
উল্টো পাল্টা
Located.
এই হচ্ছে এরা মানে
Hence return to someone.
ইয়ে বসে বসে ইয়ে দেয়
ওখানে বসেই করে দেয়।
ওখানে বসেই করে দেয় হ্যাঁ।
Suit for
But these are suit for partition, my lord.
can one. So
Can
what
one
is
is
your
my my lord, only
application?
when I'm specifically my lord, there is can one is my injunction, my lord, not to
Hmm.
for not to transfer, not
What
to
injunction you are seeking?
my lord, I'm only seeking for my lord, not to transfer, not to my lord, in respect to that should be a status quo in respect to possession, character, nature and character, and my lord transfer. And my lord, let that preliminary decree, final decree may not be drawn up till the pen.
You are in the property.
I am only in the property because he's he doesn't live in that
So
property.
how he will alienate?
Man, the problem is when he'll go for the preliminary decree and he'll execute it, man.
So we will, that we can do, but why you are
But
seeking
stay-
status quo?
But status quo, mal, if he transfer in the meantime, my lord, mal, because 1/3 share has been declared in his favor. And mal, our specific case is that there is, mal, I have also produced that this property was purchased, mal, as of my fund. This is a joint property purchase, man. It's not my father's property inherited. So, mal, this case, mal, has to be, mal, if there is no status quo, mal, then if you transfer, mal, then the again outsider will come again. I have to.
Stated that in your petition
Yes, man.
that there is a threat of alienation. You have quoted the grounds in your stay application.
Yes, yes, man. That
Where is your averment that there is a threat of alienation? Unless a status quo is passed, you will suffer loss.
well, a status quo in respect to, mal,
Where
possession.
is please show us the pleading.
Yes, yes, madam. That man, I'm sure. Well, paragraph 12, madam.
Paragraph 12.
Yes, madam. Your petitioner states that learned court has erred in law, in fact, in not considering that the plaintiff respondent herein is not in possession of the
Yes.
suit
Where
property.
is your pleading that there is a threat of alienation?
The threat, madam, probably not.
No, for that, then how can we pass it? You have not made out a case in your application. কি করে দেবো? Satisfied with that?
Well, in
Preliminary
respect
decree
to,
can be drawn up.
well,
that
only in
preliminary
respect to
decree
then, madam,
proceed-
lordship can pass an order, madam, that preliminary decree, madam.
We shall pass. that.
Yes, and madam, status quo in respect to possession, madam. But that, madam, as I am in possession, madam, I am entitled to that.
Was
Well, I have stated, but that I have stated. Madam,
you are
paragraph
in
2.
possession, all
Yes.
right. Where is your prayer that there is a threat of alienation?
Madam, threat of alienation, madam, madam, I cannot, madam, come with new facts now, madam.
No, unless you say that, how can you get an
But
order?
there cannot be, madam, it is always presumption that there is always a threat.
Oh, we have to proceed on presumption.
Well,
And
if-
what is the necessity of filing
Well,
an
lordship,
application?
well, application, madam, I have filed only in respect to, madam, so there was status quo to be passed. In the possession, madam, at least possession, madam.
পৌঁছে দিতে হবে আর নাহলে ওটা তুলে নিয়ে ফ্রেশ করে ফাইল করে
তো লিখিনি।
হ্যাঁ লেখি
ও গ্রাউন্ড গুলো কোট করে দিয়েছে।
Madam, 2000, madam, we have purchased the property and since 2002, he is not in the property for last 20 years.
If any such occasion arises, come back to us. No,
Madam, the lordship will finally, madam, stay the, madam, execution of the, madam, preliminary decree.
we'll do that. That we will. do.
Yes, yes.
The commissioner appointed.
Well, that I have to take instructions, madam. Probably he will be appointed. But I don't have any in respect to that information.
আচ্ছা ক্যান 1 of 2022 2020 every year of service filed by the appellant spoke applicant is kept on record ঠিক আছে stop in spite of service in spite of service বলতে পারছি না একটা
না,
ফেস
তুমি-
সার্ভিস করে আসলে হতো এখন তো কিছু ইয়ে হয়নি
It cannot be located.
Located.
He was, notice was sent to him at his registered address as stated in the case.
Uh,
But it has come back with the observation.
এত বড় দরকার actually it is a service not affected
অন্য সার্ভিস করে আসতে
সার্ভিস করে আসতে হবে একটা কেস সার্ভিস করে আসতে হবে। একটা সাপ্লিমেন্টারি এফিডেভিট ঠিক তাই না আর নাহলে এখন ওই কমিশনারের যে অর্ডারটা দেওয়া হয় সেই
ইউজুয়ালি
দেওয়া হয়
ফাইলে সাপ্লিমেন্টারি এভিডেন্স
Very well, well, I'll find. But then in that case, well, only status quo in respect to possession, well, I'm seeking only. Because
your service is not complete.
well, service, well, lordship, well, will
You serve
at
along
which
with
address, well, the address, it is a plaintiff's case, well, the address which is be mentioned in the plaint, I have to serve there, well, I cannot go and serve in a different address, well. Lordship will kindly cease, but because he
Your-
doesn't live over there for last
your-
20 years.
your appeal is of 2020. Your application was filed in 2020.
Yes.
You were sleeping with the matter.
No.
Suddenly you came up in 2023, mentioned the matter, you are here.
Very well. Well, then, well, lordship will kindly grants me leave. Then, in that case, I can file a supplementary affidavit in respect to the stay application. Well, if some facts I can bring before your
Come with
lordship.
that we will
Then,
go.
well, in the meantime, well, let there be stay in respect to
Sorry.
the execution of the case.
Sorry.
Well, they will proceed with the
what execution preliminary degree
well,
it
preliminary
is not
degree.
executed
Well, lordship will kindly see. Then, our final degree will be drafted, and the
I-
lordship knows that. Well.
oh you final degree commissioner will be appointed
Yes, yes, well,
on the basis of the application which should be filed by either of
yes,
any
yes,
party.
Yes, yes. Well, I understand what is falling from your lordship. Well, but in the meantime, well, some
আসুন এটা তো আসলে কমিশন তো রং প্রসেস কমিশনার হিয়ারিং হবে তাই না রং প্রসেস দে হ্যাভ গট নো আইডিয়া প্রসিডিওর সম্বন্ধে বলে যাচ্ছে
Yes, you are giving supplementary evidence or
well, I'll give a supplementary. Lordship, give me 2 weeks time. Well, I'll give it with all the necessary facts. Well, is as of but in the meantime, well, kindly pass an order in respect to the
come with this. Ashok,
হ্যাঁ
affidavit of service filed by the appellant be kept on record. Stop. No one appears today on behalf of kept on record. Stop. Mr. Chattopadhyay and the advocate appearing for the appellants. Please for leave to file a supplementary affidavit to the application being Can 1 of 2020. Stop. Such prayer is considered and allowed. Let such supplementary affidavit be filed within 2 weeks.
this one, 2 weeks.
Stop. List the matter for further consideration on 7th June. Stop. The appellant is also directed to intimate this order along with a copy of the supplementary affidavit. Is directed to intimate this order and to serve a copy of the supplementary affidavit upon the plaintiff respondent.
অ্যাপ্লিকেশনটা সব করুন ওটাও তো
Application করেছে?
না ওটা তো ফেরত চলে এসছে
তাহলে ওরম লিখে দাও কবে 7 the appellant is directed to serve copies of the application and the supplementary affidavit to the plaintiff respondent
Well,
along with a copy of this order and to file an affidavit of service on the
well,
return
only
order.
one indulgence, my lord.
List the matter accordingly on. ওটা
Well,
বলা আছে?
only one indulgence, my lord. Again, I'll serve in that address, my lord. If I'll try to serve on the learned lawyer who is appearing for the trial court, my lord, I'll try to serve.
আজ লিখে দাও serve the copy of the application along
Yes.
with the supplementary বলেছেন to the plaintiff respondent and also upon his learned
Learned lawyer,
advocate who entered appearance on his or her
Well,
রবি
his behalf in the learned court below. তারপর ওটা continuation.
therefore.
Lord, I'm appealing for the petitioner, Lord, appellant petitioner. The plaintiff is the appellant before your lordship, Lord. So the application stay of the execution, Lord, the fact of this
Have
case
you
is,
served
Lord, it was served originally and second time also the notice.
on court's order?
It's a, no, not court's order, Lord, for mentioning before your lordship, Lord. I'm told by my
But
junior.
there has to be a formal order of service.
Initially, it was served in 2020.
Sorry. Serve and come back.
It was another notice and then
Huh.
only for notice, but because copies have been served on them. So BSNL, my
How
lord,
many respondents? One respondent.
probably the matter has been mentioned with notice, blood. I think so.
Advocate is there. Their advocate
Nobody,
is appearing.
blood, nobody's
Mention slip of application.
mentioned. Slip the BSNL, yeah, mentioned. Slip has not mentioned.
এরা দেখবে না কিছু না মামলা লিস্ট করে যাবে বুঝেছো তো? তোমরা এবার লিস্ট করার আগে একটু দেখে নেবে যে ডিফেক্ট আছে কিনা। এমনিভাবে যদি চাকরি দেখো, your junior does not instruct you properly.
Well, may I look into this?
And this way matters are mentioned. We believe the advocates. Sometimes it is not brought to our notice.
I think the suit, since the suit was filed prior to the amendment, so naturally at that point of time, 10,000 rupees of court fees were paid. And the
Your
fees
advocate on record will not see the stamp reporter's report.
ought to have been looked into that.
Then
Ought to have been. No, there is no
he
excuse for
mentions, he mentioned the matter. It is our general procedure that all fresh applications will be automatically added.
listed.
But none of them point out that this is the problem. I will come on that day. I will deposit it. Does the deficit code here?
But this probably blood, this, but the stamp report has given two reports, blood. I am finding blood. One is for deficit court fees that will looked into. Second is about the delay. My lordship knows this was the delay because of the COVID-19 period.
No, that we do not
No.
know.
But
That
that
we
was,
do not know.
suit was filed, but the decree was passed on 16th
See
of
his
March.
recording. Please see his
Is
recording.
the time up to 27th of February 2020. That was because of the reason, not this. That the decree was passed on
থেকে বাদ গেছে।
16th of March, I think so. May I look into this, blood?
হচ্ছে তো তোমার
So this was
3
probably not
থেকে
correct.
28/2/2000
ইয়েটা লিখে রেখেছিল। তোমার তো মুখস্থ থাকে, আমার তো মুখস্থ হয় না।
15/3 থেকে 28/2/2022
It was passed and again corrected, my lord.
উপরে যাবে, বুঝেছো তো?
এটা কি স্টে চেয়েছে ডিসমিস করে দিয়েছে কি স্টে হবে ডিসমিসালটা স্টে করবো
না সেইটা নয়, বলতে কি চাইছে আর কি।
Yes, but the decree was passed on 29th of November 2019. And then it was rectified on 16th of March 2020. And the lockdown started immediately thereafter. I think our High Court was closed from 16th of March, if I remember correctly, my lord. 16th of March 2020. And the part of the lockdown was lifted sometime in July, August. Then we obtained the certified copy and immediately after filed it.
So we will ignore the report. You tell us you will ignore
Lordship.
the report.
So for the third item, fourth item, serial number 3 is concerned with your lordship has to pass an order. Very well, I file an application for condoning that delay also. And so far, insufficient court fee, it has to be paid. It has to be paid.
and
I'll
suit
give
has
us
been
some time.
dismissed
Lordship,
suit has been dismissed
suit has been
but
dismissed.
you have sought for an stay of operation of the judgment and the
No,
decree.
my lord, the suit
The
has been
suit
dismissed.
has been dismissed.
May I tell you, lordship, I would not have. I filed this because at the bottom of the just ordering portion, certainly the learned judge passed an order directing me to return such materials of the BSNL, which is impossible after 20 years. And nothing at all, no demand, no proof, nothing at all. Their counterclaim has also been dismissed. No court fees have been paid on the counterclaim.
Oh.
Very
Then it is
peculiar judgment. I'm so
directly
sure lordship, the appeal is
excess
hard out.
court to the office of that portion.
Everything is in my favor. Only the learned judge says that the work order that you have disclosed, which is matching the same exhibit, the defendant has also disclosed it. Work has been completed, exchange is functioning, BSL is earning profit. I'm not getting my money. Part of the work orders have been paid for, part not have been paid for. That's the only one made in the suit. The landed is held in the counterclaim also. But this has to be paid for.
এবার হচ্ছে 27/2 হচ্ছে 27/2 থেকে 15/10 27/2 এইখান থেকে
27/2 থেকে 15/10/2020
এখানে দিলে রিপোর্ট জাজমেন্ট
27/2 থেকে 15/10 15/3 থেকে তো 15
এডেটটা এখানে ইয়ে হিসেব করে 27/2 থেকে 15/10 পর্যন্ত হিসেব করে দিয়েছে 231 দিন।
তার থেকে তো এই পিরিয়ডটা
এই পিরিয়ডটা 15/3 থেকে ওইটা বাদ যাবে, তার মানে 27/2 থেকে 14/3। আচ্ছা, ডিগ্রি হয়েছে
still there is a delay.
হ্যাঁ 29/11/2019, এখানে 90 দিন। ইউ ক্যালকুলেট judgment and degree 29th November 2019.
It was rectified on 16th of March 2020.
Yes, 16th of
Unless the rectification is done, my lord, my
no,
limitation will not start
here 16th of March 2020.
20. And the lockdown, probably the entire lockdown started. High Court closed from 16th of March.
You explain
Whether
that
the rectification
filed an
will not
application.
delay it back,
Well, I think I should have filed that.
rectification will not delay it back.
But unless the decree is rectified, I cannot
Rectified
get a
maybe,
certified copy of the decree.
but as and when the rectification will not delay it back to the date.
But the decree will be read with this 29th of May 19th to 29th of November 2019 with 16th of March 2020. The delay will commence, or rather my time will commence from 17th of March 2020. But the lockdown started probably High Court closed on
Yes.
16th of March.
Okay, you
But kindly give me liberty to file an application.
learned
along with
advocate
this-
appearing for the appellant,
But I'm the appellant, plaintiff appellant.
plaintiff appellant. Prays for an accommodation to cure the defects as pointed out in the report of the additional stamp reporter. Stop. In view thereof, let the matter go out of the list for the present. Stop. Liberty to mention.
Would your lordship kindly give me to file an application also for condonation for explaining this delay?
We have said that you will cure.
Cure. Very good.
Date of the
হ্যাঁ সেইটাই।
to correction for the 10 বছর পরে কি করবে ঘুমোবে?
But 5, I beg to appear on behalf of the appellant that that my advocate on record will not receive notice for mentioning of the matter before your lordship's court. But perhaps this is arising out of commercial judgment. So your lordship though have determination in respect of the first appeal, but in respect of an appeal arising out of a commercial court judgment, your lordship do not have the determination. Determination is lying in courtroom number 37.
Have you brought the commercial act you have brought?
No, today, I have not. This matter, the paper book is being complete. Though it's the application, it's coming under the heading application, but no application is not pending.
Application.
No, the application that was at the time of admission of the appeal, the application was being disposed of. Thereafter, direction for filing of the paper book was being made. We have also filed the paper book on behalf of the appellant.
That's commercial court. Okay, this present appeal is arising out of an order passed by the Judge Commercial Court at Alipur
In
কমার্শিয়াল সুট বলা হয় নাকি? টাইটেল সুট তো এখানে দিয়েছে, কিন্তু
নাম্বারটা কি?
টাইটেল সুট নাম্বার 26/2020।
নাম্বার দিতে হবে।
হ্যাঁ,
Suit number passed by such and such. So this could
Title suit number 26 of 2020.
হ্যাঁ commercial suit একটু দেখে নিতে হবে।
It is registered as commercial suit. Why as title suit?
Milord, in Alipur, Milord, it is Milord in the caption that in the learned commercial court at Alipur, now thereafter title suit is being registered.
But it should be registered as commercial.
But
We do not have the determination. Accordingly, the matter is released from our list.
Yes.
Grateful.
May please, your lordships. Lord, this,
First time
yes, Lord, it arises,
application served. Order was there.
Lord, we have not served, not because we do not know where to serve. I will be seeking your lordship's leave. A suit for eviction decreed in my favor. Now, Lord, while decreeing the suit, Lord, mean profits which has been allowed only till the date of the decree, whereas it should be till the date of possession being delivered. And Lord, the amount which has been given is a fixed amount of rupees 500 per day per month, without Lord appointing a commissioner in terms of Order 26 Rule 9 and giving an amount even less than the admitted rental amount. So Lord, the limit, Lord, of my appeal is only with regard to the portion by which, Lord, the mean profit has been directed at 500 rupees per day per month till the date of judgment.
No inquiry under order.
No inquiry
20
under Order
Rule 12
26
has
Rule,
been ordered.
in terms of Lord, Section 212 or Order 20 Rule 12 or Lord, Order 26 Rule 9, no inquiry. Straight away in the operative portion, and that's the only line, the operative portion of the decree. Nowhere, Lord, is there any reference to mean profits. If your lordship please comes directly to the operative portion. Lord, this is Lord, page 48 of my application under Order 41 Rule
There is a
3A.
delay, Mr. Sir.
Yes, there is a delay. It's Order 41 Rule 23A application. But Lord, why I have come up before your Lord, Section 5 read with Order 41 Rule 3A, because once it's an appeal, Lord, it will be guided by Order 41 Rule 3A.
That has to be served.
Lord, the difficulty is that I've obtained a decree for eviction. Lord, the execution has been levied and I've obtained possession. Now, Lord,
You have
yes,
opted possession.
yes. Now, Lord, where do I serve, Lord,
Why are you?
only on the question of mean profits, Lord, because it's a huge amount. It's a 1400 square
You're
feet
lucky
flat.
enough that you have got the possession without initiating any execution proceeding.
No, in terms of
huh?
execution, Lord,
In
the
terms
seal
of
bailiff went and was able to obtain possession. They filed an appeal also in the High Court.
Means profit.
Lord, this is a 1426 square feet flat on Middleton Row.
একটা inquiry হবে এবং সেই inquiry-তে
Lord, almost 1500 square foot flat
You,
in
sir,
Middleton Row,
that
Lord,
is-
very close to Loretta House, walking distance from Theatre Road, where 500 rupees per day per month, where the admitted rate in 2011 agreed rent was not 1100 per square feet per day. Agreed rent was 1100 per square feet per day. And we have got 500 without any inquiry and only till the date of the judgment. Lord, the learned judge had to appoint a commissioner for making an inquiry.
You understand?
Now, Lord, why I have come before Lordship?
you serve
No, that is the difficulty why I have come before Lordship. Lord, I have evicted them.
Advocate.
Lord, that is one leave. And the other leave is, Lord, lot of times the advocate says, I am no longer holding the brief. We had mistakenly filed an application, Lord, under Order 20 Rule 12. All the post decree, which we ought not to have. We have withdrawn that application. There entered appearance. Lord, kindly give us liberty to serve at the address indicated in the Order 20 Rule 12 application, which is a new place we have come to learn they are staying. Lord, if your Lordship is pleased to come to, Lord, page 81, we'll serve on the advocate and at this address, Lord. Please come to page 81. This is the new address. This is not in the cause title of the suit, Lord, so I have to take your Lordship's leave.
appellant is directed to serve the copy of this application being can of 2023 ঠিক আছে, upon the respondent at their new address, ঠিক আছে, as and appellant is also directed to serve the copy of the application upon the learned advocate who entered appearance before the learned court below to represent the respondent, ঠিক আছে, intimating that the matter shall appear for further consideration on 7th June
And to file an affidavit.
and to file affidavit of service on the returnable date. New address বলে দিয়ে দিন। ঠিক আছে। আমি এরকম অনেক কম্পিউটার অর্ডার দিয়েছি যে ওরা পয়সা পেয়ে গেল, বলে স্যার আমার
Lordship, item number
আমার কথা শুনছি, আমি আর কিছু করছি।
Your Lordship, item number 7, Mr. Arjun Samanto is appearing for the appellant. It's a change brief. He has been newly appointed, and unfortunately, he's suffering from an eye infection at this moment.
What is the application about?
I have no idea, Your Lordship. It's a very new brief that has come.
What is it? Dekhi application.
I'll be praying for Your Lordship to keep it someday next week.
You complete service. No?
Kindly.
It delayed. Application. Remove the defects. You have not removed the defects. Putting name of the document tally with that in the certified copy of the decrees. What was the suit for?
Your Lordship, I have absolutely no idea. It's a very new brief, Your Lordship.
এটা কারেক্টেড করে দিয়েছে। বিশ্বজিৎ সেনগুপ্ত হয়েছিল কুন্ডু,
এখানে তো
করে দিয়েছে। এইটা তার মানে হয়ে গেছে, এটাও হয়ে গেছে, মানে মোটামুটি ডিফেক্ট কিওর। এই যে দেখছি এখানে as per the order of the register administration chapter, এটা হচ্ছে কারেক্ট করে দিয়েছে।
ঠিক আছে,
অ্যাপ্লিকেশনটা হচ্ছে স্টে।
he is coming tomorrow.
Next week, Monday, if Your Lordship keeps in Monday.
টাইটেল এক্সিকিউশন হয়েছে
Monday.
Grateful.
আগে ছিল এটা, not today করো।
Your Lordship, appearing for the appellant, I appear for the respondents number 1 to 4, my lord. The leading counsel is on his legs in court number 5, Your Lordship.
You are for respondent.
Not all the
The
respondents, my lord,
application.
1 to 4. My lord, this is, my lord, arising out of an application for grant of letters of administration, my lord. My lord, the one of the alleged beneficiaries, my lord, she was not given anything by dint of that will. My lord has challenged it by way of an appeal. My lord, this application is for, my lord, injunctive relief so that I do not, my lord, create third party interests, etc.
You
Well,
are in possession.
I am in possession, my lord. Only,
He is also residing there.
yes, my lord. My lord, all of us, my lord, are legal sons and daughters, my lord, widows of the, my lord, the testator.
Right.
She's the widow.
Property in the property which is
All of them are residing, my lord. These are inclusive of, my lord, orchards, my lord, cultivation land, dwelling houses, all of it. My lord, these are exhaustive properties.
And Your
Well,
Lordship,
we
I
are-
have no instruction regarding the matter, so I cannot even oppose these statements. So Your Lordship, kindly adjourn the
I
matter.
will
for
not
today.
speak
Then
the
why
horse
did
back.
you mention with notice? When you are not in a position to do the matter, why do you waste time?
Your Lordship, my senior is in position to do the matter.
Where
but
is your senior?
he's on his legs in court number
Ask
5.
him
Your
to
Lordship.
come. Pass over.
Pass over, Your Lordship. Much obliged, Your Lordship.
Just one my lord, on the last occasion, my lord, your lordship had pointed out, my lord, there was a deficiency, my lord, in the court fee. My lord, the deficiency in the,
Thank you.
my lord, I don't know, my lord, whether that has been cured yet.
That has been filed.
I just, because the regularization had to happen.
Alright. Tomorrow করে দিতে হবে।
Not today.
All right, come tomorrow.
Very well.
এই বিন্দু বলা এটা অনেকদিন ধরে কিন্তু করছে। Well, I am for the append, my lord. So this is a
Matrimonial. Matrimonial.
no. This is regarding the preemption under Mohammedan law.
Difficult topic.
Service করেছে?
Served.
Well, sir, lordship. Very interesting point, lordship. So, the learned trial judge in the order sheet admits that I'm a co-sharer, and then I'm injuncted from transferring or letting the property. It admits that I'm a
It's
co-sharer.
an interim order.
Interim order. This is against this order after contest,
So maybe, but it was an injunction application.
injunction application.
So it has to be admitted.
That's true, lordship.
We don't have the determination for admission of order 41 rule 11.
But this is under probably order 43.
This is, they have disposed of your application under order 39 rule 1 and 2, read with 1.
Lordship, correct. No.
The present appeal arises out of an interim order passed in title suit number 799 of 2021 and needs admission under order 41 rule 11. Stop. This court does not have the determination to hear the same, and as such the matter is released from our list.
না ঠিকই লিস্টে কোথায় আছে?
Your order under challenge is which one? Date of the order is
27 The date of order is on page 29 of my
27th February
27th February
ওনার নাম দিয়ে দিন।
2023.
Yes,
Lordship, the next matter also not the same order because this
Same.
is in this matter husband has purchased, there's a wife has purchased. Same
oh, আচ্ছা,
two set of property, same parties, same order.
same order.
10 and 11 Lordship. Grateful Lordship. It was an interesting wonderful Lordship at this one, but since the determination not there. Admission করিয়ে নিয়ে চলে আসুন।
Where is your other side? Where is your other side, Mr. Singhania?
I'm not seeing him here. Yesterday, Junior was there. He told that
Right. After vacation. Okay. হ্যাঁ বলবেন।
Seventh June করে দাও তো। Will appear on 7th June after vacation. এই অর্ডার করতে হবে।
এটা সেই মিস্টার লক্ষ্মী গুপ্তা একটা পক্ষ ঢুকলো হ্যাঁ উনি আছেন ঠিক আছে I'm extremely sorry, Lord. Extremely sorry.
I appear for the respondent steel authority of India.
ওনারা তো বলেছেন বোধহয় কথা বলবেন এটা কি সাপ্লিমেন্টারি এফিডেভিট দেওয়ার কথা ছিল
May it please your lordship, my lord, I appear for the writ petitioner appellate. My lord, I am led by Mr. Dotto.
কাজের বক্তব্য অন্য একটা পক্ষকে দিয়েছে আমাকে দেয়নি আর ওরা বলছে যে কাজের বাইরে যে টেন্ডার দিয়েছে তার বাইরে কাজ করেছে
Now, this exception you have used an opposition. You
No,
have taken as.
They have taken out subsequently after the pleadings are complete.
Huh.
Lordship may recall that during course of hearing, my lord, they say they would like to bring some documents on record. Is what is according to them, my lord, this may, my lord, aid to the final disposal. My lords have granted them leave. Against to that, we have taken out an exception, and our and counter to our exception, they have filed a counter.
You have filed.
This is the result.
Yes, my lord, in other way, my lord, counter or rejoinder, whatever it might be.
Counter.
So, any of Mr. Gupta or any of recapitulated the matter.
My lord.
In brief.
May it please your lordship.
Uh,
My lord, there was a, my lord, contract, my lordship.
ম্যান্ডেমার সাথে শুনেছিলাম ওই কি পাথর কাটার পয়সা
কোনটা কাটুন এক্ষুনি কোনটা কাট
পাথর কাটা না কিসে পয়সা এক পক্ষকে দিয়েছে একজনকে দেয়নি এরকম কি ব্যাপার
Yes, tell us.
My lord. My lord, may kindly comes to my lord, first the impugned order that is before your lordship. My lordship will find, my lord, in the memo of appeal also, my lord. May I, my lord, first read the impugned order.
Is it annexed to your stay application?
My lord, it also annexed. But I was looking from, my lord, this,
You place it from the memo, but can you tell us the page?
of course,
It's quite
445.
445.
তার থেকে মেমো দেখছি
Thankful to my learned senior friend, my lord, kindly comes to 445. I was actually looking from the memo of appeal. My lord, may I read? 445.
ডেসপারেট নয় ডেসপারেট নয় আমরা
ডিরেক্ট ইন্টারেস্ট পাচ্ছিস ওটুকুকে করতে আসছিস বলতে ভাবলি হবে ওটা একটু যেই দেখলো সার্ভিসিং যেই দেখলো একটু ডিসপিউট একটু তাহলে সুপ্রিম কোর্টের কাছে যায়
সেইটাই
Yes,
The order starts at page 445E, capital E.
yes, yes.
That the petitioner had undertaken extra work. The work undertaken was in respect of a contract entered into a partnership. One of the partners was paid by the respondent number 1. He submits that there is no justifiable reason for the issuance of the impugned memo. The learned advocate for the respondent number 2 submits that the dispute relate to a commercial contract between the parties. The contract contains an arbitration clause. The petitioner has already applied for reconstruction in accordance with the terms and conditions of the contract. Consequently, the writ court need not interfere in the present writ petition. The learned advocate for the petitioner, in reply, submits that the additional work does not come within the scope of the contract, and therefore the arbitration clause of the contract does not apply. Moreover, the representation made by the petitioner has not been considered till date. I have considered the rival contention of the parties and the materials available on record. the petitioner and the respondent number 2 had entered into a commercial contract. The impugned memo is dated January 30, 2015. By such memo, respondent number 2 had sought to repudiate the contract. There are disputed question of facts involved. One of the issues raised is whether or not additional work undertaken by the petitioner comes within the purview of the contract or not. As a writ court, I am not minded to enter into such disputed question of facts on affidavit. In such circumstances, the writ petition is disposed of without any order as to cost. Now, this was what would germane to your lordship from the order impugned. Now, kindly first comes to
Taken was in respect of a contract entered into in partnership.
page number 434. May I just start?
1 minute.
Second paragraph.
Partnership.
The what?
My lord.
What does it mean? Come to 445E.
Yes.
Learned
Partnership, my lord, there was.
Learned advocate submits that the petitioner, there were two petitioners.
No. Yes. Yes.
There was, this is a partnership, this is a private limited company.
This is a private limited.
So what does this sentence means? Advocate for the submits petitioner had undertaken extra work.
Yes.
The work undertaken was in respect of a contract entered into a partnership. What does it mean?
Lordship is reading from
Assigned.
445E. My lord, that what your lordship wants to know that here lordship is reading, my lord, from the 445E first page. The advocate for the respondent number 2 submits.
No, not that. Your second
Prior to that, the
second paragraph.
yes, had undertaken extra work. The work undertaken was in respect of a contract entered into a partnership. Now, my lord, the petitioner, along with the pro forma respondent, they entered into a joint, my lord, agreement. My lord, so far as
Pro forma respondent.
pro forma
Who
respondent.
is that?
My lord, there is an iron exchange, and my specific case before your
So
lordship,
you entered into a partnership with respondent number 8.
my lord,
And you participated in the tender.
my lord.
process.
And that is the case, my lord, that is what is recorded over here, that I, along with one iron, we together, my lord, entered into a joint venture, and we together formed a partnership in view of the Indian Partnership Act, section 19, lordship is quite aware. And we, my lord, also participated in the contract, and we were awarded.
What was the what?
My lord, work with regard to, my lord, some, my lord, cabling work, excavation, my lord, etc., etc. My lord, it's all with relief.
Then what happened?
My lord, there was certain, my lord, if your lordship kindly comes to, my lord, I would just show, kindly comes to page 4.
When was it sent to consortium?
Lordship?
2% consortium was there.
No. There was no consortium. My lord, kindly comes to page 433.
433.
My lord. My lord, firstly, my lord, kindly see 434. My lord, principally, these two documents will give, my lord, subject to correction, a better appreciation of the facts that why I am before your lordship. Kindly comes to page 434 first. This letter was issued by the ISCO addressing to Proforma Iron Exchange, which was, my lord, also amongst a part, my lord, in the partnership firm. It was of dated 12th August 2011. Kindly also, my lord, underline the date, because the next letter I will be going to show to your lordship. This was issued after to this. This was issued Iron Exchange India Limited, such and such, subject intake works, plant MW and DW system, package number 20, contract number such and such. We approve the change order for the work specified in change proposal and agree to adjust the contract price as per the terms and conditions of the contract. Number 1, title of change, extra work. Kindly, my lord, appreciate this, extra work. Extra work for intake works, plant MW and DW system, package 20. Then, my lord, certain charge request number such and such. Then, my lord, the change request number such and such, change order number such and such, originator of change J. Goswami such and such, authorized price, extra work for intake works, plant MW, TW system, package 20. Now, what comes under the authorized price for extra work? Number one, overhead cable, bridge for laying cable between such and such, LP such and such, including all taxes. Then, rock cutting and disposal. Well, my claim is with regard to the rock cutting. Same claim, similar claim on similar circumstances at similar place where the claim of iron was allowed. My claim was rejected. That is why I first show the document by which the claim of iron was allowed. Now, rock cutting and disposal, WTP area of rupees such and such, total such and such, revised contract price is such and such. Now, kindly, Miller, mark the date 12th of May 2021, and they approve this for extra work, and under this same intake work, plant MW, DW system for rock cutting. Now, Lordship, kindly, Miller, turns back one page, 433. And also mark the date. This was much after 31st January 2015. Miller, kindly read from, it was addressed to me, and kindly, Miller, mark the subject, and kindly find, Miller, whether there is any dissimilarity with the purported, Miller, that claim of the respondent that there are some dispute, whether they are at all in dispute or not. Subject extra claim for intake work, plant MW and DW system, package 20. Contract reference number, it's the same contract reference number of 28 November 2018. Lordship may kindly tally 433, 434. It was addressed like this: please refer to the following extra item raised by Mrs. P.K. Thakur, that is me, for MW and DW package. A. Additional excavation work due to change in alignment at site, rock cutting and disposal during excavation of works reservoir. C. Building up of additional embankment as per instruction of ISP/MECON. MECON wide letter reference number dated 20th October 2014 recommended that the following two claims of Mrs. P.K. Thakur are admissible. What are admissible? A. Superfluous work of excavation and building up of embankment at original location of reservoir. B. Building of embankment on the southern side of the reservoir. These two also extra work. Now, the last part is important, Miller. However, your extra claim regarding rock cutting and disposal during excavation of works reservoir has not been made tenable by MECON. With reference to above, you are requested to attend a meeting with the deviation committee such and such today in the project office. Now, Miller, who is MECON? MECON is their agent, who is, Miller, basically a consultant. Now, Miller, I had the agreement, rather, Miller, precisely subject to corrections, Miller, I, along with ION, we had entered into agreement with ISP. Now, Miller, so far as this extra works is concerned, and that is a subject matter of adjudication by your Lordship, that these extra work, Lordship, kindly tally this last portion with the last portion of the letter at 434, which was addressed to ION, and where this, Miller, under Roman small 2, rock cutting and disposal, the claim was allowed. And this is with regard to, in reference to same project and under the same area. And both of us, Mallard, we had, Mallard, executed this work. And this was beyond the periphery of the contractual terms. This was something, Mallard, which was done in extra. And this is not a case, Mallard, that...
Why, please explain this pay. 434 was of the year 2011.
Mallard, both the claims were processed. Now, one claim...
Where is the letter similar to this issued to you?
Mallard, that is similar to issue at 433.
433 is a letter issued 4 years after the issue.
No. My claim was under process. My claim.
Which document shows that you were asked to do that extra work?
Mallard, their letter itself admitted. Their letter itself admitted.
Which letter?
This letter, I would show, I have other document, but this letter, 433,
yes,
it doesn't say that I was not asked to do the work.
Basu,
and they have also not said that.
So, Basu, we are not asking. We are trying to understand.
My lord.
You, both of you as a partnership firm entered into the contract,
My lord.
completed the work, additional work was asked to be completed.
Lordship,
So by a letter of 2011, one of your partner was said that you do this, we approve the change order and we agree to adjust the contract price as per terms and conditions of the contract,
my lord,
which includes rock cutting and disposal.
my lord.
But this was addressed to the pro forma respondent.
Yes, one was addressed to me, one was addressed to pro forma
Where
respondent.
is your letter?
My lord, my letter is at 433. Lordship has looked into.
No,
33 is
the-
after 4 years.
Yes,
Yes,
it is in respect of the claim raised by you.
yes. Now, this is in so far as 433.
My lord Justice Chakraborty trying to
I have followed.
ask you to show that rock cutting and disposal was allotted to this work was assigned to you. That letter.
Very well. My lord, kindly comes to my lord, my exception.
Agree to adjust the contract price as per terms and conditions.
Of the contract.
এই extra workটা হবে
সেই এক্সট্রা ওয়ার্কটা করেছিল, এবার এক্সট্রা ওয়ার্কটা একে দিয়েছে
একই টাকাটা দিয়ে
দিয়েছে কিন্তু ওর বক্তব্য ওকে দেয়নি। কিন্তু
সিমিলার এক্সট্রা ওয়ার্ক করেছে ওকে দেয়।
হ্যাঁ, কিন্তু ওকে যে অ্যালট করেছিল এই রক কাটিং ডিসপোজাল সেই চিঠিটা পায়। এখানে একটা কি দিয়েছিল সয়েল টেস্টের ব্যাপার।
পাসপোর্টটা দেখো 434 অরিজিনেটর অফ চেঞ্জ, অরিজিনেটর অফ চেঞ্জ পাসপোর্ট
হ্যাঁ
সেটা হচ্ছে মেকন।
হ্যাঁ
অথরাইজ তার মানে মেকন কি করি ওকে এক্সক্লুড করে নিয়ে ওর সাথে এক্সট্রা করতে দিয়ে refer to following extra claim results. Addition is a due to change of cutting. As the clause C that as per instruction of Mekon. Mekon wide letter dated 2014 recommended the following two claims. Mekon বললো
Madam, may I just show to your lordship that in other way around, my lord, what my lord justice has followed from my lord Chakraborty, that the work was allotted to me. My lord, I would show from the supplementary affidavit so far as that particular document is concerned. I may require some time, but in other way around, I would show I would show to your lordship that so far as my lord allotment and execution of this document, my work was never been disputed. What they say,
Please read page 433 once again.
my lord.
যদি নাই দিয়ে থাকে
Yes.
এক্সট্রা ক্লেমটা
Please refer to the following extra claims raised by Mrs. P.K. Thakur for MW and DW package. Additional excavation work due to change in alignment at site. B. Rock cutting and disposal during excavation of work reservoir. That is the subject matter. C. Building up of additional embankment as per instruction of ISP Mekon. Mekon wide their letter reference number such and such dated 28th October 2014 recommended that the following claims of Mrs. P.K. Thakur and company are admissible. What? A. Superfluous work of excavation and building of embankment as per original location of reservoir. B. Building of embankment of the south side of the reservoir. However, your extra claim regarding rock cutting and disposal during excavation of works reservoir has not been made tenable by Mekon.
now what was the amount of your rock cutting value?
My lord, the amount of my rock cutting value,
Your claim in the writ petition
my lord,
must have been the claim. You are
Yes, yes.
demanding that. মেকনটা বলে দিবেন
লেখন করে কাজটা দেখবে।
করলো রক কাটিং আর ডিসপোজালের জন্য টাকাটা দেবে।
নট টেনেবল, ক্লেম নট টেনেবল।
My lord, kindly comes to
So, Mr. Basu, what we
Page-
understand from you is that your partner was given a work outside the contract for excavating and extra work. And you were also allotted similar type of work. When he placed his bill was approved, amount was paid to him. But your bill was responded by this 433. Whereby
sir,
your two claims were allowed and two claims rejected.
one claim, that rock cutting.
Build,
Rock
no,
Yes, out of 3, 2 were allowed.
Rock cutting.
One rock cutting. Rock cutting is a subject matter. If lordship are absolutely correct, absolutely
for
on the
rock
point.
cutting and disposal, they have disapproved your claim.
Is according to ISP, the MECON has not recommended for that such payment that could be made to me. So far as iron is concerned, that was being paid. The similar, the rock cutting and disposal. Now, my lord,
On page 434, we do not find any recommendation of MECON.
no, whatever recommendation, but they have found, because the recommendation of MECON is immaterial, because my privity of contract is with ISP. Now, MECON is their agent. So far as the agent or consultant is concerned, they have referred. What I am trying to persuade to your lordship, that they might or might not, but that will not make any difference. Because after all, it is for the ISP who is answerable before your lordship. And they cannot, my lord, make a shortcut theory with, my lord, introducing, my lord, some purported disputed question of fact, which is not at all disputed. I go on by the records which are admitted and which are before your lordship. There is nothing to be denied.
করেছিল যে মেকন সুপারভাইজ মেকন যদি সার্টিফিকেট দেয় তবে পয়সা দেবে।
Now, my lord, amongst the various issues that I will be trying to address and, my lord, persuade to your lordship subject to my lord satisfaction, my lord, section 70 of the Indian Contract Act, I would request your lordship kindly have a look to this. Section 70. The principle of Indian Contract Act, section 70, is this: the obligation of person, my lord, to pay. My lord, yes, lordships are absolutely correct. It is the not with regard to that. They deny. Now, kindly have a look to section 70, if may I read, my lord.
এই contract একটা দাও না।
একটু জজ সাহেবকে দেবেন। My lord, I'm extremely sorry, my lord. I should have brought, my lord. This is my fault.
দেখো না এদিকে এসে contract একটা এখানে আছে কিনা।
আমি পেয়েছি তাহলে দুজনে দেখে নিচ্ছি।
My lord, may I just read and hand over? Where a person lawfully does anything for an
Yes.
Yes.
where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such another person enjoys the benefit thereof, the latter is bound to make compensation to the former in the respect of or to restore the thing so done or delivered. So, my lord, this section 70 depends.
আচ্ছা,
Sections, I'm grateful. Section 70 depends on, my lord, 3 caveats. It has to be done lawfully. It has to be, my lord, non-gratuitous, and something which is enjoyed the benefit. If these 3, my lord, parameters are satisfied, my lord, the latter is bound to make the payment. Now, there is no dispute that I executed the contract, I executed the work lawfully. There was no unlawful things. It was not gratuitous work. I had worked, my lord. My execution was supposed, my lord, in respect of certain money, which I am entitled to. And third ingredient is that they have enjoyed the benefit. And the fourth one, which, my lord, I would try to, with all my humbleness, support to these ingredients of section 70, that on similar circumstances, other one has received the payment.
but Mr. Basu, this work which you have done for rock cutting,
My lord.
who will ascertain that? Can the read code find out
Well,
that
there
this
is-
much of work was required to be done, but you have
No. My lord, there was no issue of even ascertainment of the portion of the work. The issue is whether I am entitled of payment or not. Kindly, my lord, let us confine to this.
No,
This
no,
is
why-
not an
why?
issue of, this is not,
433.
yes.
433 says that your extra claim regarding rock cutting and disposal is not 10.
Yes, so meaning thereby,
Let us come.
my lord, my lord.
Now this rock, they have, you can argue this, that for rock cutting and disposal, I have raised a bill of 100 rupees. You are repudiating my entire claim, but you could have given me part of the claim.
Yes. Lordship is absolutely correct.
So you show us your extra claim pertaining to rock cutting, which was not approved or recommended by Mecca. Where is that paper?
My lord. My lord, that is what, my lord, I am also on. My lord, lordships are.
But Mr. Basu,
My lord.
kindly appreciate.
I have.
We asked these authorities to junior Mr. Gupta was there. We put this question.
Yes.
That when you have paid for the similar work to
my lord.
Icon,
My
to
lord.
Ion,
Ion.
why you are deprived?
Lordship
That
has
is
done
the-
so. Because this is a blatant violation of Article 14. This cannot be done because being a state authority, my lord, is lordship have tried,
Mr.
my lord.
Basu,
My lord.
we are trying to understand.
Lordship.
We have not made up our mind.
Absolutely.
We are questioning you
My lord.
that do you have any document to show that Ion completed this work, adjacent site, this much of work was done. I have also completed this much of work. His was given, mine was not. Now, whenever this issue comes out for consideration, automatically an issue arises that how the quantum of work which has been done by you can be established. Now that we cannot decide in a writ petition.
That is not even before the lordship. Issue is, because may I just summing up in other way, that issue is not that how much I am entitled. This is not an issue. Issue is not that whether I had worked or not. Issue is also not that how much I had worked. Issue is not whether.
Where is the issue that you have?
Issue is whether I'm entitled for my work or not. This is the issue.
Was that you have done that work?
There was no dispute. I coming. Kindly comes to Milan. My exception to their supplementary affidavit.
You show us 433, the extra claim which was raised by you.
My lord.
First answer our queries. Don't
Yes.
show us other documents.
Kindly comes to Miller page, my exception to the supplementary affidavit.
Please listen to our question.
My
Page 433, this letter says, please refer to following extra claim.
Yes.
Raised by P.K. Thakur.
Yes.
Where is that letter of yours raising this claim? Yes, Mr. Gupta.
This is 13 crores 89 lakhs. If your
30.
lordship takes up his exception, kindly come to page 41, their letter of 2016, but it refers to their claim lodged in 2011. At page 41. At page 41 of their exception, it is affirmed by Sudeep Kumar Thakur. Page 41, fourth line. Third and fourth.
Considered in date which was an Ion claim was 2 crores 35 lakhs.
My lord.
Mr. Vasu, let us ascertain from Mr. Gupta what is their stand.
Very good.
Then we can come back to you.
Very good. May I just also show, well, just one page? I would definitely not travel to your lordship. I would again come back whenever your lordship require me.
No coming back. We are hearing the matter.
No, today itself. Yes, no, coming back itself, I said today. After Amalot kindly comes to, sir, 2 minutes. Kindly takes up my exception. What I was trying to show, page 41, Mr. Gupta has shown. There are other documents I would come, but kindly see, the minutes of the meeting at page 35. Kindly have a look to this.
35.
35.
Yes.
Yes. Milord kindly takes up.
Yes.
Milord, this was a meeting. Milord, held.
Ion and ion.
Ion. And kindly comes to page 38. কোথায় গেল? My lord.
What you are trying to show?
My lord, so far as the payment made for extra work, that is for rock cutting. Yes, I had marked, my lord, that.
No, this is of ion.
Ion.
No, why you are showing that? That is admitted.
Admitted. That they have admitted. So far as the claim for the iron and for us, that with regard to the execution of the work and the portion of the execution, these were never disputed. But so far as the stand is that which they could not have also placed, I have not found any single sentence that why my claim was rejected under similar circumstances. And this was not a gratuitous work. This was not done unlawfully. And this is something which they enjoyed. Because so far as iron is concerned, they have enjoyed. The money was paid. So far me is concerned, that is also they have enjoyed. And under the same project.
Show us 3 documents.
Very well.
If we believe you, in that case, you have to show us 3 documents. What was your proposal for extra work? And how much was the amount for that? And why they have rejected it?
Very well.
You are saying that it is admitted, that it was agreed into, that I will do the extra work. It will be recommended by Mecon and I will get.
So far as Mecon is concerned, I executed the work for ISP. The payment will be made by ISP. Contract was executed with ISP. Everything, the Mecon is nothing but.
Explain us, why is your inhibition as regards Mecon?
Very well. I'll show.
First, so these are the issues you find out. Let us hear Mr. Gupta that why they have rejected.
My lord. Yes.
The PK Thakur and Ion Exchange, they had formed a consortium, participated in the tender process. They were selected. A tender was allotted, which is amount was 105 crores plus for doing some water and or plant, etc., which required more excavation. The contract document specifically provided that the nature of the soil, including the subsoil, which may include rock, solid, which,
is it on?
Yes, which includes the which may include rock also. The contract provided that whatever has been found out so far, it is your additional duty to find out what could be the nature of the subsoil, and in the event of something which is not so far found out by the parties, if any such job is required to be done, for that, my lord, no additional payment will be made unless you specify it beforehand. Because through drilling, etc., the processes are available.
to understand, my lord, the nature of the subsoil. The contract term specifically provided that for anything new, it will not be on subsoil. You will not be paid additional, no additional payment would be made. That was a specific term in the contract. But the contract also provided that where the employer, that is the Indian Iron Steel, Steel Authority, if they allot any additional work, that will entitle you to get additional payment. My lord, in order to make it short, my learned friend has placed 433 and 434. You'll actually find, my lord, the difference in the language in these two documents. One is a claim for additional work. The other is an extra work done. Extra work done. Extra work done on the basis of, my lord, the requirement of the employer.
But why will he make a claim for a work which has not been permitted to be done by ISP?
Not permitted to be done. It is, my lord, a part of the work which they are required to do subsoil, cutting the rock.
Yes.
They say that we are entitled to additional payment for that, but the contract says that that in respect of such jobs, such additional jobs, which you may have to perform subsoil, you have to find it out before. Any subsequent work done by you, no extra thing will be obtained. This is in respect of the subsoil conditions. This is, my lord, the clear understanding among the parties, Iron, P.K. Thakur, Steel Authority, and the consultant Mekon. Mekon is the consultant under the.
In case of iron, how did it materialize?
Because this was the rock cutting, additional rock cutting was directed to be done by the Steel Authority itself.
Upon a proposal to given by iron.
Upon a proposal being given, or maybe I do not know the extra work possibly. It says the extra work, my lord, directed to be done by Steel Authority. For that extra.
In that case, the Steel Authority allowed them to do.
Kindly, I placed 434, page 434. This is not addressed by Steel Authority to Iron Exchange. Dear sir, we approve the change order for the work specified in the change proposal and agree to adjust the contract price as per terms and conditions of the contract. The extra work is approved by a change order issued by the Steel Authority. This is an additional job which entitles Iron to get additional payment for it.
So there was a change order given by Iron. That change order was
given. That was approved in the form of an order, and then the extra work was done, which was paid for.
I see.
In contradistinction to this, kindly come to
What is this line? Agree to adjust the contract price as per terms and conditions of the contract. What does it mean?
The contract price was, say, suppose X.
Yes.
That has to be adjusted by addition.
I see. So contract price was 100 rupees. After extra work, it has come to 200 rupees.
Yes.
We will pay you 100.
Yes, exactly.
All right.
Now, my lord, kindly
So
take
your contention is that in his case, there was neither any change order.
Yes.
Nor there was any approval of any such proposal of
Yes.
PK. And as such,
it was neither approved by Steel Authority nor made tenable by Mekon. Mekon is the consultant who has to be consulted at each stage of the work being performed by the members of this consortium, namely P.K. Thakur and Iron.
But that is not reflected in 433, Mr. Gupta.
Lord,
There was no change proposed.
Lord, there was two committees. There were two committees. One was deviation committee, another committee, etc. Lord, I shall place those documents if your lordships consider it necessary at all. These were duly considered, and Lord, the claim of Thakur was rejected. Your lordship has seen, but then they were invited to participate in those deliberations held subsequently, and they are also, Lord, they failed to show that they are entitled to this. This was not a rejection straightway. They were invited, even by this letter at page 433, to participate in that discussion, and even there, Lord, they claim they could not prove as coming within the terms of the contract.
To
Now,
show
Lord,
us
these
those
are
documents. Show us those documents.
yes.
Now, only one question, Mr. Gupta. This page 432, 33, it refers to an extra claim raised by P.K. Thakur. Now, you have nowhere it is seen that the rejection was since there was no proper proposal and non-approval of proposal.
No, not exactly that. Lord, may I paste this 433
Yes, yes.
in some detail? Now, Lord, please refer to the following extra claims. In contradistinction to 434, extra work. Extra work wasn't admitted to position in 434. In 433, it was an extra claim. Following extra claims raised by P.K. Thakur. One, I leave out A and C because those are sanctioned, approved. These payments are made, additional payments. B is rock cutting and disposal during excavation of works reservoir. Now, my lord, the Mekon video letter dated so and so recommended that the following two claims of P.K. Thakur are admissible. That is A and C. Now, however, your extra claim regarding rock cutting and disposal during excavation of works reservoir, that is which comes under B above, has not been made tenable by Mekon. Mekon is the consultant, my lord. They are required to be consulted by each of the consortium as well as the Steel Authority Limited at each stage of the work. Now, Mekon, my lord, is associated with the actual process of work. They take measurement, their men take measurement, etc. of the work done, because each work has to be measured. There is a measurement book, each has to be measured. Now, whatever job is done has to be measured. Whether it comes within the scope of the additional work or within the scope of the existing work, every job has to be measured. The measurement has to take place by the subordinate authorities. All whatever work is done has to be measured. Now, whether this work A, for which the measurement is taken, and work B, for which also the measurement is taken, whether A involves original work or additional work, or B involves original or additional work, that has to be decided by the higher authorities of the Mekon. They will decide whether claim A or claim B is tenable or not. The Mekon finds that by applying the terms of the contract, the claim B is not tenable. And I'll show you, lordships, my lord, the particular term of the contract which says that in respect of the subsoil, if it is your obligation to find out, because scientific processes are available nowadays, my lord, to find out the subsoil, the nature of the subsoil through drilling process, etc., or seismic system also is there. Now, that was the terms of the contract, and that was agreed to by all the parties. Now, that particular clause.
You finish off and show the documents. This is your argument we are taking.
Yes. Now, now, my lord, this is therefore the 433, my lord, it never says that this is an extra work which is recognized. It is dealing with an extra claim. And then we do the committee, deviation committee. Right? However, towards the end of this letter at 433, however, your extra claim, etc. not. Now, with reference to the above, you are requested to attend a meeting with the deviation committee of ISP today in the project's office.
No, as you say, 434 is a claim approved.
34 is the claim.
434 is a claim approved.
Yes.
And 433.
434 is not only claim approved, no, extra work is approved. Extra work is approved, therefore the claim is approved.
Now, in this case also, they.
Extra work is not approved. They make a claim straightway. The extra work is not approved either by Mecon or by Steel Authority.
Duto approved, rock cutting rejected.
No, extra work pertaining to rock cutting was rejected.
Rejected. Two approved.
And other two were approved.
Other two are approved, exactly. Other two are approved. We are only concerned with rock cutting, nothing else.
So extra work towards rock cutting, this claim, that you are saying that there was no approval of such claim. Where do we find that letter?
Milord,
Page 434 says extra claim was ascertained. When they gave us, we approved the same. Thereafter, on the Mecon saw it and we gave the mark.
Yes. Milord, kindly compare these two letters, 434 and 430. Kindly come back to 434.
Yes.
Milord, we approve the change order for the work specified in the change proposal and agree to adjust the contract price as per terms of the conditions of the contract. Now, one, title of change, extra work. This title of change, this being changed. Title of work, extra work for intake works for plant and etc. Then two, change request, number so and so.
Who gave this change request?
Request must be request.
Yeah, ion by PK Thakur.
This is ISCO letter.
Yes,
6th of May
ISCO,
2011.
yes. Then change order.
Not
change request, my lord.
6th of May. Change order was 12th of May. Now,
Yes.
Originator of change was AGM and ION. Authorized price, extra work for intake, plant and package number 20. Overhead cable bridge for laying cable such and such. Rock cutting and disposal.
There was a proposal for change. There was an acceptance of change regarding extra work. These were followed up by extra payment. So far as ION is concerned. Nothing like that you'll find from page 433.
Page 10 supplementary.
Then in respect of additional excavation work, superfluous work of excavation and building of embankment, there was an approval. That is why that too was paid.
Yes.
That was.
Yes. No dispute with regard to that. That was accepted.
No, এই দুটোর ক্ষেত্রেও কি চেঞ্জ প্রপোজাল এবং ছিল Mr. Gupta, in respect of these two work,
Yes.
superfluous work or building of embankment, there was a change proposal on behalf of petitioner.
May not be. It could be straightway direction from Steel Authority also. Or it could be a proposal is coming which is approved. It could be either way. That is not appearing from this document. I will not go into that. But then it is what appears clearly is that these two were accepted. While the third one was, B was not accepted, A and C were accepted.
So this reasoning which you are providing, this must be reflected in the decision ultimately taken by the deviation committee who deliberated with him.
Yes. May I show to your lordship, my lord, the supplementary affidavit used by us. Kindly take, my lord. Page 10 of that.
Supplementary.
Page 10. Annexure C to our supplementary affidavit. This is dated, my lord, 8th of October 14.
What is this, Mr.?
My lord, this is
Your
note dated 39/14 from E.D. Mekon, Burnpur, for review and reconsideration by the page 10. For review and reconsideration by the committee for their observation made. Vide report of July 2014 on Messrs. P.K. Thakur's extra claim against package number Swanso stream expansion.
এই সুরজিৎ এই এসিটা বন্ধ করিয়ে দাও।
May I place this document, my lord, at page 10?
Yes.
My lord, package intake, package, etc., contractor, ion exchange, reference, etc. My lord, after the line in the middle, further to the observations made by the committee, vide their report of July 14, the following additional observations were made. Salient features of the contract, scope of facilities, refer contract agreement article 4.21. Should the actual physical quantities and weights differ from the indicated ones, neither the contractor shall be entitled to get any additional price from the employer, nor the employer is entitled to deduct any amount from the contract price due to variation in physical quantities and weight. The contract document refer contract agreement article 1.3. In the event of any ambiguity or conflict between the contract document listed above, the order of procedure shall be the order in which the contract documents are listed in article 1.2. The claims raised by the contractor, work of excavation and building up of embankment at the original location of reservoir, demolition of hard work at reservoir, and building up of embankment on the southern side. Now, contracts philosophy.
Considering this rock cutting,
Yes.
claims raised by contractor, work of excavation, demolition of hard rock.
Yes. This is rock
reservoir.
cutting. This is rock cutting.
This is rock cutting.
This is rock cutting. At
So they raised a claim.
Yes.
Now, contract philosophy.
Contract philosophy for addressing the claims as referred. In order of precedence, the article mentioned in the contract agreement will prevail over all the observations made by the committee in this finding during July 14. Change in the physical quantities of work will not have any impact on the contract price. The genesis of claim lies with the change due to interference of high tension line over the designated area as per drawing. All claims relate to the single turnkey assignment of creation of water reservoir. The change of work in the reservoir was made at the behest of the employer, and partial work done becomes redundant and hence does not come under the change as elaborated under clause 41.1 of the contract. Observations of the committee. Contract clause number 4.2.4 and 4.2.5, technical volume, stipulates construction of 2 compartment reservoir. The contractual volume of reservoir stipulates 280,000 cubic meters as per clause number Swanso. Layout drawing. These are all engineering aspects.
4.5.
4.5. Change of location for excavation given by employer or consultant to contractor vide letter number Swanso, and change was approved.
Yes.
Vide revised. I'm grateful to your lordship. BKT number Swanso, number Swanso.
So this is pertaining to rock cutting.
Change of location for excavation.
For
Excavation.
Then where is the clause for rock cutting you have said? These are all excavation.
4.9.
No, 4.9.
4.9. No claim for rock cutting or unforeseen soil condition is admissible. Inadmissible as per clause 7.5.2. This is what I was referring to, my lord, that
is subsoil position. Now 4.10, as the volume remains same, no claim on excavation is admissible on account of increase in depth of excavation.
But you have approved the excavation, superfluous work of excavation you have approved.
Excavation is approved. I am not on that really. Rock cutting is not approved. Excavation has been approved. Now regarding rock cutting, my lord, they are referring to 7.5.2.
No. 4.10 says as the volume remains same, no claim on excavation is admissible on account of increase in depth of excavation. Now read this with page 433.
No, my lord, excavation may not be on regarding the depth only. It could be, my lord, sidewise also. Excavation, I mean, to
Excavation
larger
level.
depths does not entitle.
434 excavation.
4 point.
No, our
Change in
our
location to কোথায়
quest-
পাচ্ছি?
the question which comes is 433 you have allowed their prayer for excavation.
Yes.
Though from page 12 it appears that no such excavation was admissible on account of
Kindly read 4.5. I'll be after placing these documents, my lord, for your lordship's prima facie consideration, my lord, I'll be really, my lord, harping on this aspect in this case, that this is, my lord, a purely engineering contractual matter, where possibly writ courts, my lord, do not enter into, particularly when there is an arbitration clause in the agreement. And my lord,
we were with you. We were with you. We told Mr. Vasu also these disputed questions we cannot go in.
Yes.
But when it was pointed out, the
No,
entire
my lord,
thing has narrowed down. to this issue.
excavation as per 4.10, which is not admissible, that is deep into the soil. Now there may be excavation.
That we cannot adjudicate.
My lord, 4.5. That
No,
is why I say, my lord, these are all factual disputes.
Yes.
Is it 4.5? Kindly read, my lord, 4.5 at page 11. Change of location for excavation. 4.5, change of location for excavation given by employer or consultant to contractor. Bide so and so. Now, change of excavation, change of location for excavation, that entitles additional payment. But change, excavation at deeper points, that doesn't, my lord, entitle for any additional payment. Change in location regarding excavation, yes, there is entitlement for additional payment. As this is, my lord,
Very good. This is one point. Now please come back to page 10, Mr. Gupta.
lordship.
This reference, P.K. Thakur's letter of 20th June 2015.
My lord, P.K. Thakur letter number dated 20th June, yes, 2011.
Now PKT MW dated 29th September 2014. Sale mail dated 29 September 2014. These three documents were taken into consideration and the committee opined as follows.
Yes.
Then, yes, next point, Mr. Gupta, which is your next argument?
My lord,
মিটিং হয়েছিল কমিটি হয়েছিল সেটা
my lord, if your lordship kindly take page 332. 332.
সেটা পড়িয়ে নাও।
330.
Just. Mr. Gupta, will you kindly come to page 14 of your supplementary evidence?
minutes of site issue redressal committee.
Meeting. 14.
14. Yes.
Yes.
There is site issue redressal committee.
Yes, this is issue redressal committee. One was deviation committee. As I said, you know, there are two committees.
You participated in that
Yes.
meeting. You
Yes, this-
participated. Where is your signature? DGM contact.
আর আগের পাতাটা দেখো একবার,
হ্যাঁ।
page 13. The MTP to DJM. This is written by DJM. Claim 1 work of excavation, যেটা approve হয়েছে admissible. Claim demolition of hard rock reservoir. No claim admissible as per.
Your lordship will kindly see from paragraph 5 downwards.
Yes, claim deferment were carried out by them due to change in additional extra work due to change. Matter has been scrutinized by Mekon and Mekon by letter dated such and such recommended the following.
দেখুন matter was scrutinized by Mekon. Mekon violated such and such recommended for following.
সেই দুটোর superfluous word
নেই।
this has to be এটা হচ্ছে 19/11/2014 পেজ 13 টা হচ্ছে 20/10 নিকনের চিঠি, এইটাই হচ্ছে নন রেকমেন্ডেশন পেজ 13।
This is a meeting.
Yes,
This is a meeting between ISP and Mekon, the steel authority, Indian Steel Plant, ISCO Steel Plant, Steel Authority of India Limited, and Mekon. This page 14.
yes.
I was referring to paragraph 5 downwards. The party has claimed that following extra jobs were carried out by them due to change in size, depth, and shape of the reservoirs, additional excavation, etc., rock cutting, building up. Now, the matter has been scrutinized by Mekon, and Mekon VDA letter dated so and so recommended that following two claims of Thakur are admissible. Then recommendation after detailed deliberation and discussion, committee recommends to consider following two jobs as extra jobs. Then A and B.
But Mr. Gupta, we do not find the reason for non-approval of that rock climb.
Lord, that your lordship will find at page
Deviation committee meeting এ resolution হয়েছিল।
7.5.
প্রথম ডকুমেন্ট কোনটা দেখা যায়?
If your lordship kindly takes page 12. Page 12.
Deviation committee meeting 30
Deviation committee meeting, we are coming to page 12.
Lordship.
Deviation committee meeting 16.
Your lordship is referring to page 16.
16, yes.
Yes.
Mekon করেনি।
Committee asked the party that their quoted price is very high as compared to cost estimate furnished by Mekon. Asked to justify their quoted price. So whether they raised a high price and hence rejected.
P.K. Thakur informed quoted rates are similar to rates accepted by Mekon in similar job executed by consortium in same package. Committee did not agree with the justification and intent they should not compare their quoted price with other contractors' job. Committee again asked furnish documents in support of their quoted price. However, party did not submit any documentary evidence. Committee informed cannot go beyond the rates recommended by Mekon. However, the offered rates were not accepted by Thakur. Oh. Once again requested to consider. Oh. Yes. So, Mr. Then admitted সেটা তো দিতে পারতো।
সেইটাই। যে সাইট মিটিং হয়েছিল, ডিভিয়েশন কমিটিতে মিটিং হয়েছিল, সব ইয়েতে গেছে। আমরা পিটিশন হচ্ছে ডিসপুটেড কোশ্চেন অফ একটা ছিল, আর আমরা ওইজন্য করছিলাম দিয়ে আরবিট্রেশন ক্লজ আছে,
এটা তো সবসময় করতে পারি। Mr. Gupta, will you please come to this page 16?
Yes, I am on 16.
In 16, Mr. Gupta, can you come to clause 5?
Yes.
Clause 4 and clause 5.
Clause 4, Mrs. P.K. Thakur was limited informed the committee that their quoted rates are similar to rates accepted by ISP Mecon for similar type of job executed by their consortium partner, Mrs. Iron Exchange, in the same package. Committee did not agree with the justification given by P.K. Thakur and intimated the party that they should not compare their quoted price with other contractors' jobs. Committee again asked P.K. Thakur to furnish documents in support of their quoted price. However, party did not submit any documented evidence in support of the quoted price. They are considering these additional claims. This is all regarding these additional claims.
Next paragraph.
Committee informed Thakur that the committee cannot go beyond the rates recommended by Mecon. However, the offered rates were not accepted by P.K. Thakur.
Yes.
P.K.
Now,
Thakur,
what was the offered rate? You offered the rate for his excavation work.
no,
Clause 5.
Hmm.
So pay him the offered rate, Mr. Gupta. So
this
when
is
there was an
this meeting is not for rock cutting. This is for all the three claims.
no clause 5.
Clause 5, committee, the committee cannot go beyond the rates recommended by Mecon.
That
Rates
is
recommended by Mecon is not below with regard to rock cutting. Additional rock cutting is never, it was held to be untenable. That it doesn't cover rock cutting.
Claim regarding cutting and excavation has not been made tenable. Informed on
মানে
that.
ইয়ে কোটেড প্রাইস রিগার্ডিং ওই
Superfluous
সুপারফ্লুয়াস
work of excavation এর জন্য।
এমবাঙ্কমেন্ট এটা রক কাটিং নয়, it is not related to rock cutting. Page 16 is not related to rock cutting
Page 16 is not related to rock cutting only.
only. Yes.
It relates to 3.
Other two.
Yes. Yes.
এটাও রক কাটিং, 17টা রক কাটিং নয়।
Paragraph 6 will make it clear.
Hmm.
Paragraph 6 at page 16. Mrs. P.K. Thakur once again requested ISP to consider the same rates for their executed jobs as accepted by ISCO Mecon for similar type of jobs executed by their consortium partner, Iron Exchange.
But this is not for rock cutting.
This is not for rock cutting.
And next page is also for not, they raised this bill. The superfluous work was ultimately allowed.
এই যে
Superfluous work, yes, that the two.
Well, may I, with all humbleness, just to,
Wait, just.
well,
wait.
this relates to rock cutting. See para 2, page
Paragraph?
16, page 16, para 2. It is I am my lord's officer. My lord may see that whether I'm correct or not. Kindly see para 1. Para 1, so far as extra 2 claims, it was settled. They say that is approved. Now, para 2 onwards, the entire discussion was with regard to rock cutting.
No.
No.
You kindly come to page 3, para 2, third line.
Yes, exactly.
Yes.
Para 2, third line.
Yes.
Committee also informed the party that the right now committee would discuss only first claim of the party, such and such.
Superfluous work.
Filling up of embankment. It's not.
Now, my lord, if that be so,
No,
then
no, that we so na. Please let us read
Very well.
together.
Yes.
Committee also intimated P.K. Thakur that their extra claim regarding rock cutting and disposal during excavation of rate of work reservoir has not been made tenable by Mecon.
Hmm.
So your that excavation work was also found not tenable.
Hmm.
Now next, committee also in that right now, committee would discuss only first claim of the party, that is superfluous work of excavation and building of embankment at original location.
but if
So,
your
Your
lordship,
rock cutting was excluded
but if-
and said that your first claim of superfluous, there was a dispute. You said that you give me the rate which you gave to iron.
but no,
Committee
but
said,
if,
no,
if
we
you,
will not
if you,
give you that. We are offering you a rate. Are you ready?
but if
Then
you,
when this was the next page 17,
yes,
you came out of the meeting and gave a letter,
Yes.
2nd February,
Yes.
that all right, give me this much of amount of rupees for excavation,
Yes.
which they have allowed.
yes, now, my lord, if your lordship,
25
very well, I will answer, because let Mr. Gupta complete. I will only just show Because if that be so, then para 1 in page 16, kindly see deviation committee informed Mr. P.K. Thakur that following 2 extra claims have been accepted.
Right.
Now,
That is
this
superfluous work of execution and building of embankment. There, rock cutting is not included in that. Now, so far as claim 1 is concerned, that extra claim regarding
well.
committee intimated that their extra claim regarding rock cutting and disposal during excavation of work has not been made tenable. So they will only consider on superfluous work of excavation.
And that is their point. Very well, I'll come back.
Mr. Basu.
Very well, I'll come back.
Repeated questions. We cannot.
No, that is there. That is they say. That is they say in their supplementary. That is they say. I will answer this.
As you made such a confident argument, we took it up.
My lord, I am still confident. I am still confident. Anyway, this document has been looked by me.
Basu, you have tried your best.
No, I have not. My lord, I have not yet. Well, I have not yet exhausted. I have not shown my lord, many other parts. My lord, Mr. Gupta was only my lord, is on list.
We all have labored together to see if anything can be done.
No,
But
consider
unfortunately,
329
Mr.
was the
Basu,
main
this is
contract.
a disputed.
No, there is no dispute. My lord, Lordship, kindly hear me out. There is no dispute.
Clause.
My lord, that the part which they are showing.
Yeah.
That they are showing. Well, let Mr. Gupta complete.
This hearing cannot go on indefinitely.
No, I do not even say so. I do not even say so. Let Mr. Gupta complete. I was I have also looked to this document and I thought, but now let Mr. Gupta complete. Thereafter I will answer.
Yes, Mr. You answer. He has finished. You answer.
My lord, I just show your lordship one document, one clause in a document, page 332, which I already referred, my lord.
30?
332. 332. Clause 7.5.2. It is, my lord, Macon had referred to this while holding that it is not tenable.
332.
332, page 332, clause 7.5.2.
Yes.
It is presumed that
Just one moment.
Macon has referred to this clause.
Wait, referred to it.
Macon has referred to this particular clause in rejecting their claim for rock cutting. 7.5.2. Not at page 434. Not at page 433.
No, not that. We are seeing your supplementary affidavit where
Yes.
the clause has been
Yes,
quoted.
lordship. Page 12, if your lordship kindly.
Page 12.
Page 12 of
What?
my supplementary affidavit.
7.5.2.
Lordship.
That is at page 332.
Yes.
Yes, what do you want to show?
332. These are the general conditions of the 332. Shall I place this? Or your lordship has seen this, 7.5.2.
7.5.2.
Yes. It is presumed that the contractor has already inspected the site and satisfied itself about the actual site conditions and has collected any other information which may be required by the contractor. All necessary soil tests over and above those carried out by the employer are to be undertaken by the contractor, and no extra claim on this account shall be admitted.
But Mr. Gupta, this extra work is beyond the contract.
But this is a part of the contract. That if
any extra work is done.
Because it is your responsibility to find out before you undertake this, before you enter into this contract, to find out, to hold soil test in the depth and find out what is there. On this account, you will not be entitled to make any additional claim later on. It's your obligation.
All right.
And then page 329.
329.
Just 3 pages before this. That's the arbitration clause. At the top of page 329. Any disputes, differences whatsoever arising between the parties out of or relating to the construction, meaning, scope, etc., that be settled between the employer and the contractor amicably, and failing that, this arbitration. This arising out of etc. My lord, the P.K. Thakur's objection was that since it is a job outside the contract, if it doesn't, the arbitration clause doesn't
Which
apply.
clause you are showing?
My lord, the clause, my lord, this is page 329 top,
Yes.
arbitration.
Arising between the parties relating to construction is operation.
Meaning, scope, operation or effect of this contract shall be settled, etc. between employer amicably, if however the employer and the contract are not able to resolve their disputes or differences amicably as aforesaid, shall be referred are settled for conciliation, failing which to arbitration.
It is beyond the
Conciliation where, arbitration where, etc. Arbitration actively applicable.
contractual terms.
Contractual terms as per Mr. Gupta, যদি কোনো চেঞ্জ হয় তাহলে চেঞ্জ প্রপোজাল পাঠাতে হবে। সেই চেঞ্জটা অ্যাকসেপ্ট অ্যাপ্রুভ করতে হবে তবে ওনারা
Acha, only show us another thing, Mr. Gupta, that your supplementary affidavit. No, sorry, page 333. Sorry, 433.
433. Yeah, what can you?
With 430 last line. With reference, you are requested to attend the meeting of the deviation committee. Where is the meeting resolution? This 30th of January 2015 that you have brought in through your supplementary affidavit.
Possibly, my lord, yes.
Do you have that resolution here?
And 30 ওইটা দেখো তো কত তারিখের 30th January 15 কিনা দেখো 30th January 15 কিনা দেখো 30th January 15. Yes, this one. My lord, page 15. Page 15 of my supplementary affidavit.
সাপ্লিমেন্টারি না সাপ্লিমেন্টারি এফিডেভিটটা দেখুন। হ্যাঁ
কোনটা
আছে ডিভিয়েশন কমিটি মিটিং আছে।
কোনটা
এই তো ডিভিয়েশন কমিটি 18 পেজ 18 তার আগে
না সে তো অন্য, আমি বলছি এইগুলো চলছিল তো লাস্ট কমিটি
30
এই যে ডিভিশন কমিটি মিটিং পেজ 16
পেজ 16 আছে।
সেটা হচ্ছে 28 নভেম্বর 2008।
ডিভিশন কমিটি
অনেকদিন ধরে চলছে।
ওটা আবার 18 একটা কি যোগ করেছে 18 পেজ আছে
এইটাই
এই যে মিনিটস অফ ডিভিশন কমিটি
এইটাই নাকি
কবে পেজ 16 টা কবে বলো তো? পেজ 16 এর মিটিংটা কবে?
পেজ 16 এর মিটিংটা 30
জিটা কোন প্যারাগ্রাফ
30/2015। হ্যাঁ
that is page 16.
কন্ট্রাক্টে এক্সট্রা ওয়ার্ক নিয়ে কিছু বলা আছে কি?
বুঝে
333 তে প্রিজাম্পশন চলবে।
presumption for 330 extra. It is presumed.
But
Inspector satisfied is the actual site plan and has collected any other income which may be required.
ওই যে উনি যে বললেন না যদি কোনো চেঞ্জ হয় তাহলে চেঞ্জ প্রপোজাল পাঠাতে হবে, সেটা অ্যাপ্রুভ হবে তবে পয়সা দেবে, সেই ক্লজটা কোথায় আছে?
Where is that clause, Mr. Gupta, that they have to claim that extra that has to be approved and then only payment will be made? Is there any clause in the contract to that effect?
I haven't
Change proposal, that change proposal is to be approved.
I just
ও ওনার সাবমিশনে দিয়ে দিয়া ওনাকে বলুন মিস্টার বোস কি বলতে চাইছে।
Yes, Mr. Vasu.
may I refer to two judgments, because one is
Yes.
There are four different situations where a REIT is not entertained by your lordships in a contractual matter. First of all, where, my lord, there is a concluded contract.
the contract is concluded. First, there will writ petitions are not entertained because only monetary claims arise there. Concluded contract, then where there is no public law element, where there is disputed question of fact, and where there is arbitration clause.
Yes.
All these have been considered in one judgment of the Supreme Court, 2021, volume 10. Supreme Court cases 690. May I place that judgment?
Paragraph.
Paragraphs, I'll be relying on paragraphs 18 and 24.
Yes.
About the nature of the job, which was part of which was a contract, paragraph 4 is relevant. This road construction, etc., which also requires excavation and all. The paragraph 4 gives the facts. I place paragraph 18 for the legal proposition. Mr. Paragraph 18. Mr. Nataraj also placed reliance on the judgment of this court reported in Joshi Technologies, wherein the following was held. Law in this respect, or in this aspect, has developed through a catena of judgments of this court, and from the reading of these judgments, it would follow that in pure contractual matters, the extraordinary remedy of writ under Article 226 or 32 of the Constitution cannot be invoked. However, in a limited sphere, and such remedies are available only when the non-government contracting party is able to demonstrate that it is a public law remedy, which such party seeks to invoke, in contradistinction to the private law remedy, simpliciter, under the contract. Some of the case laws to bring home in this cardinal principle is taken note of hereafter. On the basis of these facts, this court observed that the aforesaid observations of the High Court relying upon Ramana Dayaram setting were not correct. Thus observed the court, speaking through Justice Pandian. Paragraph 21 is quoted. This finding, in our view, is not correct in the light of the facts and circumstances of this case, because in Ramana Dayaram setting,
Settled proposal.
yes, absolutely. There was no concluded contract as in this case. Therefore, if it is a concluded contract, Dayaram setting, the principle is not applicable. Even considering that the BDA has the trappings of a state or would be comprehended in other authority for the purpose of Article 12 of the Constitution, while determining price of the houses or flats constructed by it and the rate of monthly installments to be paid, the authority or its agent are entering into the field of ordinary contract acts purely in its executive capacity. Thereafter, the relations are no longer governed by the constitutional provisions, but by the legally valid contract which determines the rights and obligations of the parties interstate. In this sphere, they can only claim rights conferred upon them by the contract in the absence of any statutory obligations on the part of the authority in the state contractual field. There is a line of decisions where the contract entered into between the state and the persons agreed is non-statutory and purely contractual, and the rights are governed only by the terms of the contract. No writ or order can be issued under 226 of the Constitution, so as to compel the authorities to remedy a breach of contract, pure and simple. Now, there is no public law element. Your Lordship has seen this. Now, paragraph 69, again, I quoted. The position thus summarized in the aforesaid principle has to be understood in the context of discussions that preceded, which we have pointed out above. As per this, no doubt, there is no absolute bar to the maintainability of the writ petition, even in contractual matters or where there are disputed questions of fact, or even where monetary claim is raised. At the same time, discretion lies with the High Court, which, under certain circumstances, it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. 69.1. The court may not examine the issue unless The action had some public law character attached to it. 69.2. Whenever a particular mode of settlement of dispute is provided in the contract, the High Court would refuse to exercise its discretion under Article 226 and relegate the party to the said mode of settlement, particularly when settlement dispute is resorted to through the means of arbitration. Now, 69.3. If there are various serious disputed questions of fact which are of complex nature and require oral evidence for their determination, then 69.4. Money claims per se, particularly arising out of contractual obligations, are normally not to be entertained.
Yes.
Except in exceptional circumstances. Then the other paragraph that I had.
Para 24.
Therefore, the dispute could not be raised by way of a disputation on the disputed questions of fact. Though the jurisdiction of the High Court is wide, but in respect of pure contractual matters in the field of private law, having no statutory claims, are better adjudicated upon by the forum agreed to by the parties. Agreed to by the parties. The dispute as to whether the amount is payable or not, and or how much the amount is payable, are disputed questions of fact. There is no admission on the part of the appellant to infer that the amount stands crystallized. Therefore, in the absence of any acceptance of joint survey report by the competent authority, no right would accrue to the interpretation only because the measurements cannot be undertaken after passage of time. Maybe the resurvey cannot take place, but the measurement book of the work executed from time to time would form a reasonable basis for assessing the amount due and payable to the petitioner, but such process will be undertaken only by the agreed forum, named the arbitrator, and not by this court, as it does not have the expertise in respect of measurement or construction of it.
Yes.
The other judgment regarding the scope of the arbitration clause. Why I beg to cite this judgment is this, Lord. My learned friend says that they have taken a point. Since this claim is not arising out of the contract, is not a part of the contract, this is an additional claim. Therefore, the contractual term of arbitration is not applicable to this claim. That is what they say. Now, what is arising out of contract has been explained by the Supreme Court, not only to cover what is there. This is 2019. 2019, volume 5. Supreme Court cases 192. Paragraph I just give 192. Paragraph 7. Paragraph 7 at page 202. The arbitration clause in 2007 scheme clearly states that all disputes arising out of this scheme or in relation thereto, or any form whatsoever, shall be dealt exclusively by way of arbitration in terms of Arbitration Conciliation Act 96. Russell, in his commentary on arbitration, has interpreted these words as follows: disputes in connection with or in relation to or regarding a contract. These words, which are frequently encountered and are to be given the same meaning, were at one time given a restricted interpretation, but are now well established as having a broad meaning. They may also be sufficient to catch disputes arising under another contract related to the contract containing the arbitration clause. In Renu Sagar, this court observed that expressions such as arising out of, or in respect of, or in connection with, or in relation to the contract are of the widest amplitude and content. In Dwapak systems, this court observed that expressions such as pertaining to, in relation to, and arising out of are used in the expansive sense and must be construed accordingly. The words in relation thereto, used in clause 11.12 of the 2007 scheme, indicate that the clause would apply to all transactions which took place under the 2007 scheme. This would include the sale transactions in the present case. In view of our discussion, the view taken by the at the conclusion of the hearing, the Supreme Court is itself, my lord, appointing an arbitrator. That is paragraph 8. My lord, here the clause, my lord, at page 329, the arbitration clause is very expansive.
Yes. Yes. Yes, Mr. Basu.
My lord, may I take my lord finally?
Yes.
Say on one hand, that the walls, you know, colored or whether the walls that were dark, this was not admissible. And Marcel Muller, he has also said that if anything, whether any claim arises out of the extra work, that has to be acted. Now, this all says whether by way of a supplementary evidence and subsequently after the opinion. And introducing whether something else might be what was given not clear for. Rothschild may have also taken a note that he has referred nothing from his opposition which he has used against my fear. All document whether that he relies purportedly on behalf of the highway with regard to the supplement. Now, from the supplementary evidence, whether the submission that Mr. Gupta has made the first document that he refers at page 10. For the so far as page 10 is concerned,
Yes.
the clause number 4.9 at page 12. This was a note which have brought into light by James and we have supplementary evidence. Now that note, 4.9 and 4.10, my lords will point out. And 4.9 says that no claim for rock cutting and unfortunate file condition is admissible as per contract clause 7.5.8. Saying 4.9 says, as the volume remains same, no claim on excavation is admissible on account of increase in depth of excavation. Or subject to note that it was a evaluation from the side of IL that these extra claims have been made if there was a change of position. If there was no change of position, original position, there should not be any claim for it. Now, while my lord was point out clause 4.10, Mr. Gupta has answered by referring to clause 4.5 and 8.11. Now,
No, excavation, we are not on that. Your claim is that rock.
So far as the excavation is concerned, that what you lordship have said and what he has answered.
No, excavation has been allowed. No?
What he said.
We are not on that. We are restricting ourselves to rock cut.
He said that it cannot be done in case of the original position. But even in case of the original position, that claim was happening. So Gupta was referring to us point, what I was trying to point out that it is then who has referred. And while minors have pointed out, he was trying to take shelter of 4.5. Now, finally, Miller,
No, for change it is approved. He said for the depth, 4.10 is pertaining to the depth of excavation. Kindly see 4.10 as the volume remains same. No claim on excavation is admissible on account of increase in depth of excavation. And 4.5 is change of location. What you are saying is the other round. For change of location, approved. Change of location, it can be approved. So far as depth is concerned, that can be. No, they whatever that we are not concerned with that. We are not concerned with that, Mr. Basu.
They say that it's only for the change of location, but it is not. It is the same location. So it is not a case that where the only the in the change of location, that payment has to be approved. Even in the same location, because at 434, that payment was made. Is the original location. He has referred to this 4.5 with regard to 4.10, that is why I have pointed. Now, whether here, if you not see whether there a deliberation is that it is not an extra claim, something an extra work. And so far as Thakur is concerned, it is the extra claim. Now, the lordship looks into page 434. Whether this extra claim was made, how an extra claim would arise? It is only because of an extra work. If there is a work, there is a claim. If there is an extra work, there is an extra claim.
যদি অ্যাডমিশন থাকতো আমরা রিড কোর্টে দিতে পারতাম।
There is an extra. Now, what it looks into clause 1, title of change. Here the issue was this in this letter, that what are the claims for extra work that were considered. And in that claim, what was considered amongst others, one was rock cutting and disposal. And the similar fashion, as far as 433 is concerned, my claim was also amongst others was with regard to rock cutting and disposal.
But that was not approved.
That was not approved.
And that is a non-approval is at page 16.
Now, so far as their stand is concerned, so far as 416, this is that what Mr. Bhutto has shown, that at page 16 clause 4, or if I apply it from clause 2, that the HT has stated that their extra claim regarding cutting and disposal, including excavation rock reservoir, has not been made enabled by Macon committee and informs the party that right now discuss only first claim of the party, that is super for of excavation and building up to impacted and political stop. Now these are the only things. Now for one it was recommended, one for one it was not recommended. Now this only this figure of line that what we have showing, that for one part it is recommended and other part it is not recommended. Now kindly appreciate the work was not disputed. So far as
How can you say that? They are disproving your work.
they are not disproving.
It is your claim has not been approved. One of the reason is Macon has not recommended, whatever may be the reason.
Other way around, how the Macon, so far as there was no even rejection from ISP.
Exactly that whether there was approval or not, Mr. Basu, this can be gone into pertaining to facts for which you have to lead evidence. We are only on that narrow scope of judicial review. In tender matter, we usually do not run a fine comb over the factual matrix. It is a blatant arbitrariness on the part of the government. Yes, we have appreciated that.
Because there was nothing to be has been gone on record that this work was not done, or this is not with regard to the same project, and this is also not a case that iron was not paid. And I have brought also 5 judgments with me that this is a creation of a dispute will not trigger a dispute in the case. There has to be shown that there is some dispute. They are creating a dispute. As far as the arbitration for an existence of that there are federal judgment even in 2022 that arbitration clause will never be a bar. The subordinate legislation cannot go over the constitutional provision. 226 court can certainly enter. I have also brought for other judgment. Because it will not say kindly see whether they are supplementary evidence. So far as they are,
We have seen that. Please do not repeat. Any new point you want to say, you say.
there was no dispute with regard to my job circumstances. Now the only point is
So that is the greatest dispute. They say that we have not approved. We have not approved, as has been done in case of Ion.
If it is being approved, then obviously the payment would have also been made. Then their approval and non-approval.
Non-approval or approval?
One case, can they approve and other case can they not approve? So it is not a case of an arbitrariness and culpability appears on the face of the record that the work was not disputed. Now, if on the other way now, Lordship has, he has also referred to clause 7.5. Now, there must be one argument that either there was no work or there was out. If it is not approved, then so far as 7.5.2, how would come to rescue? But so far as approval of the aspect is concerned, kindly visualize. For one case, they are taking not any rescue, but rescue of 7.5.2. So far as my case, they are taking a reference of 7.5. So far as their case is concerned, we have not. Now they cannot take both the points together. Either it would be a case of 7.5.2 that the work was done within the project. That is why it is not happening. What at best is subject to correction if I have understood correctly. Because according to them, if 7.5.2 stands, then the work was within the project work, and that is why it was not approved, and that is why it was not found in. Now, if that is so, so far as I am is concerned, they could not take a different and a standard variance. They cannot say that no, for your work, it would not come within the 7.5.2 because it's a similar one at a similar project at a similar place, and the work was for rock cutting. And whether it is not also a case that so far as my works were done, it was done unlawfully. There has been no answer to my one of the point which may strengthen my case that I rely on section 70 of the Indian Contract Act. It was not done gratuitously. It was not done unlawfully. It is not even a case that they have not utilized my work. They are the beneficiary. Now, if they are the beneficiary, it is an obligatory part of them under the Indian Contract Act, and being it a concluded one that they have enjoyed the usufructs out of this, that they have to pay me the compensation. And the compensation is to be paid out of the bill which is submitted. It is not a case that so far the quantum of the claim is disputed. It is not a case that how much I have worked, it is disputed. Because if those are disputed, that which is subject to correction will require evidence to be pleaded. That whether I had worked for 100 meters or whether I had worked for 50 meters or whether my claim that to enter three crores is acceptable or whether the claim with regard to now if that is so, but there has been no and not
whether Thakur will get or not, or PPS to what extent? It is a determination required.
I have never relinquished my claim so far as their case is concerned that so far as their case is concerned, then I did not pursue. I have relinquished my claim. I have never relinquished my claim. So far as my lodging of claim is concerned, that was with them. They other than page 433, and so far as clause page 60 is concerned, they have no other document that why they did not find.
Please don't repeat, sir. You have made that argument.
I would rely on page 2007, volume 13, page 544.
Volume 13 SCC.
Page 544.
Volume 13, SCC, page 544.
This was with regard to the nature of entitlement. But kindly come to paragraph 2 and page 546. Challenging the appeal. Challenging the appeal as to the judgment of the division bench of such and such High Court, holding that the suit filed by the plaintiff was to be partly decreed for recovery of such and such, the present appellant together with the pendant such and Ahmedabad such and such for in recovering amount without receipt such and such. It was further stated that the appellant corporation by the later date such and such directed the respondent to handle more cargo than what was prescribed above, and consequently the respondent herein started handling
The suit, Mr. Vasu.
well, suit,
This
but a
is in connection with the suit.
suit. Now, Millard, I would refer to the principle what has been Millard followed.
Applied in suit.
Millard, so far as also in the constitutional court, Millard, that
Was that paragraph?
my lord kindly comes to
This is not a writ appeal.
yes. Millard, this is not a dictatable. Millard, I would only try to show Millard paragraph
19 quantum
paragraph
period.
19 at page 551.
That is quantum mediate section 70 of contract.
Yes.
You have
Now-
argued that.
Now, if your lordship kindly para 19 and para 20, that I would be referring, Millard, and para 21. The principle of quantum merit is often applied when some technical reason for some techniques the contract is held to be invalid. Under such circumstances, an implied contract is assumed by which the person for whom the work is to
No
be
dispute as that proposal, Mr. Vasu. Dispute is questioning whether any work was done of which they have enjoyed the benefits. Your contention is good, bad, indifferent. I have done some work. You have enjoyed the benefit of such work, and now you are denying me compensation. The very issue to that is a dispute which you cannot establish unless you lead evidence. That see, this is the portion, this is the area which I have done.
Millard, then Millard, if your lordship, Millard, whether Arab is with me, my client or not, then lordship kindly may subject to correction required to read Millard. So far, their affidavit in opposition and exception. At nowhere, Millard, in not even a bold sentence, Millard, they say that I did not execute the work. Your lordship will not find it. Lordship will not find a single sentence. Let them show from their affidavit. I'll be
They
thrown
have
out.
finished their argument.
Millard, then Millard, kindly
Forgetting about the earlier argument which you advanced. We have taken note of your argument.
my lord.
Now you are reopening the case.
But I am not
Then
reopening.
We can never finish, man.
But I am not at all reopening because lordships are going on the premise that so far as my work since being disputed and only on this issue, 226 court cannot enter into. And I have to lead evidence. Now, lordship, for that purpose, there is not even a it is affirmed in July 2022. Kindly comes, at page 5.
Page 5.
Page 5.
Yes.
Millard, so far as prior to that, kindly see one paragraph at page 2, paragraph 5. There only Millard stand is that this is a money claim, and that is why it's being a money claim. Millard, no public law element is involved, so the writ court should not interfere. Now, so far as clause 7.8 is concerned, Millard, they go on the basis that there is an arbitration clause or whatever the dispute, it has to be sent to the arbitrator.
What is paragraph 9?
9 is 9 and 10. Your lordship may recall they have referred an award with regard to the works pertaining to the contract. We initiated an arbitration proceeding under section 11, and in that case, one arbitrator was appointed and he has passed an award.
That was relating to what?
That was related to the works executed pertaining to the agreement. Pertaining to the agreement, which and this claim which I have referred now have come before your lordship, that was not related to the contract, because my consistent stand is it is an extra work. And the judgment what I was trying to refer to your lordship, possibly para 21 I should have placed to your lordship that 2007-13, that the term extra is generally used in relation to the works which are not expressly or impliedly included in the original contract. Price, provided the work is within the framework of the original contract, the question whether a particular work is extra will depend upon the terms and conditions of the contract and the documents connected there. Is 2007-13 para 21 defines the definition of extra. Now that is why in para 9 and 10, when minor justice Chakraborty was pleased to kind enough to inquire that this is not falling within the scope of the contract, we did not initiate any arbitration proceeding out of this. Now, so far as para 11-12 is concerned, now kindly comes to para 5 that I have initially referred to. The petitioner had referred the dispute arising from a contract to arbitration and nothing prevents such.
Is the matter as for orders in the daily supplementary list of this order?
For minor's convenience, may I only take a short indulgence? In order to summation, may I just file on the next day 1.5 page a note giving my bullet points and the judgment that I have been referring, just the giving the indication.
Want that if you want to prepare, you prepare.
Very well.
We are not asking for any written argument. কবে দেখেছেন?
ভর্তি আছে নাকি? আমাদের 19 তারিখ করে বন্ধ।
17th রেখে দাও। 17th May.
17th May for judgment.
My lord has kept it for orders.
For judgment, my lord, for order. For orders,
For orders we have kept.
for orders.
He will complete his argument, whatever judgment he
My
wants
lord.
to show. You give the list of judgments which you are referring to your friends.
I will, my advocate on record will send him address.
I'm grateful.
Deeply.
Extremely obliged.
17th.
70.
I will, in the meantime, I would try to only just move out from that one issue, that whether it can be considered by your lordship in some more better way.
With my lord's leave. My lord, আজ করবে না পালা তাকে যেন পরে পাঠিয়ে আজ করবে না।
What happened?
My lord, may I have your lordship leave to mention, my lord, item number 19, my lord.
I am for the respondent. That matter is continuing.
And for the respondent number 1.
In the result, the appeal succeeds, judgment and degree are set aside. It is held that a scheduled property cannot come within the hodgepodge of the suit for partition, and the suit in the present form is dismissed. Parties shall bear their own cost.
Get it in the uploaded.
I was making my submission. কস্টটা কত কথায় আছে রে? যেগুলো বেঁধে রেখেছি এগুলো রিলেভেন্ট প্যারাগ্রাফ গুলো বার করা আছে তোর কাছে?
27 লাস্ট বলেছিল।
Yes.
Will kindly come to page 86 to recall the evidence of Mr. Giridhari Lal Parikh on behalf of the appellant. Is the father of the husband, ex-husband. I had placed this. Now, I am placing in the context of that the gift. Your Lordship may remember on the last occasion, I pointed out, by referring to the evidences, the snippets of which, will point out that, all the persons who had gifted the money had gifted it, with an intention to gift it to the wife. But it was routed through the husband because the husband needed, an inflation of his bank account for the purpose of visa. Therefore, whether this money can be, said to be a stridon for the purpose of recovery.
Yes.
About fifth line from top at page 86. In the year 1994-95, Sanjay had sufficient fund for studying in USA. In the year 1994-95, Sanjay received gift of rupees 3,41,000 from 11 persons. There is an admission. Then says, the period from October 1995 to March 1996, he received the said gift. Therefore, there is an acknowledgement of this gift. I did not submit any paper showing that the amount of fund lying with Sanjay apart from the said gift of rupees 3,41,000. Therefore, Lord, evidence of receipt of Lord this gift is acknowledged by the father. I cannot file any document since the incident occurred long ago. I do not remember whether some of the donors were the relatives of Mohanlal Parikh, the father of the plaintiff. Out of the 11 persons, some gave 31,000 and some other gave multiply of 31,000. Some of such gifts included gifts from HUF. Out of the said persons, there were only one relative of myself. He was Prem Parikh. I do not remember whether there was any relation between Prem Parikh and Mohanlal Parikh. My son Sanjay was a scholar, and for helping his education, all those persons gave the said gift of rupees 3,41,000 to him. I had sufficient fund for his educational expenses. And then, Lord, the next page, that the ornaments, Lord, we are not in possession of the ornaments of Madhusri. It is a fact that in the police station, we offered Madhusri to take back some of her ornaments. Some of her ornaments, Lord, I emphasize. Therefore, something is there still retained with them, but for which, Lord, the degree had followed against them. I do not remember whether Madhusri took back her ornaments or not. Yes. Then, Lord, again in 89, page 89. On the cross-examination, Lord, he is wavering on the statement. About, Lord, seventh line, Lord, it is sixth line. The Honorable Court directed us to take the ornaments to Hare Street Police Station. We took the ornaments to Hare Street Police Station. I cannot remember whether did I take back the ornaments or not. I cannot remember whether ornaments were handed over to Madhusri or whether we obtained any receipt in connection with the said delivery.
Regarding ornaments to বলেছে এখন এই মানিটার ব্যাপারে তো বলছে ornaments তো both side বলেছে
এটা কি প্রিন্ট আউট করছো? কি প্রিন্ট আউট হচ্ছে? কোন জাজমেন্ট?
এখন তো পরে করছো তো এখন
কোন জাজমেন্ট? ও আচ্ছা আচ্ছা,
পরে
পরে সময় পাচ্ছ না?
সময় করে করবে এখন কোর্স চালান। হ্যাঁ,
Lord, I was Lord, reading about Lord, the sixth line from top at page 89. Honorable Court directed us to take the ornaments. We took the ornaments to Hare Street Police Station. I cannot remember whether ornaments were handed over to Madhusri and or whether we obtained any receipt in connection with the said delivery. I don't have any document in regard to the said documents, but I have got certified copy of the order that we have placed. But thereafter,
হ্যাঁ, that evidence regarding ornament was brought to our notice.
Yes, my lord, I have.
Now we are on the gift.
Well, just when I am on that page, I am just
Yes,
reminding
yes,
you,
yes,
Lord. Lord, one or two sentences. Then, my lord, so far I can remember the said locker was surrendered by my son Sanjay Parikh, defendant number 1. About, my lord, fifth line from the bottom, sixth line from the bottom.
Hmm.
Okay. Then on page 90, I was not present when the locker was surrendered. Page 90.
Yes.
And whatever I deposed, Lord, I pointed out it was a hearsay evidence for that. Then, Lord, in that page 90, out of 11% deposed in a case in Alipur court in connection with making gift to my son. Bottom portion of page 90. One is my relation, others are not. Premshuk Parikh is my relative. I have no document to show to this effect. It is fact that Premshuk Parikh is the cousin brother of Mohanlal Parikh. Now it comes
1 minute.
Out of 11 persons, how many deposed?
But about not 4 or 5%. Well, I'll give you a lordship, Lord, that
No, deposed in connection with
criminal case, not here.
Not
Here, nobody has come.
Yes.
But the evidence tendered in the criminal case was marked as an exhibit in this particular case.
Oh, it was marked as
Yes. Therefore, it is in the part 2 of my lord's brief, the paper book.
না Mr. Mukherjee শুনিয়েছিল একটা।
Yes, yes, yes. One.
Lord, that your lordship will find, Lord, 68 to 165 in exhibit C at part 2 of the paper book. I mean the volume 2 of the paper book.
It's 68 to
165. ও কতগুলো উইটনেস ছিল একটু দেখে দেন না ছোট্ট করে কেউ আছে তোর পাশে 18 উইটনেস পুরোটা আমার লাগবে না আমার লাগবে খালি ওই ডোনার উইটনেস 3 জন না 4 জন আছে একটা থেকে but your lordship requires the donor witnesses only I believe
yes,
the donor witnesses yes but that is about 3 or 4 persons I give your lordship the name.
all right, you continue.
Lordship. Then, Lord, here that I have no document to show to this effect. It is a fact that Premshuk Parikh is a cousin brother of Mohanlal Parikh. Mohanlal Parikh is not my client's not father. Out of those 11 persons, 5 persons deposed in the Alipur criminal court. But he says so 5% out of 11 when I was present. Not a fact that they deposed in their evidence that they made the said gift for the marriage.
not a fact.
Not a fact. But Lord, when I pointed out the evidence of those persons, Lord, your lordship, on the last day, I can even point out the pages today, that some of the witnesses in the criminal case said that the gift was intended for Lord, my client. And at the request of the father, it was given to the son-in-law because he wanted to have not the account, not balance updated for visa. But that is not the position of Lord, the evidence of Dharilal Parikh, Lord, that is the father of the husband. না কতজন আছে এখানে বলছে 5 জন 5 জনই কি আছে লিখে না কোথাও একটা লেখ অশোক সুরানা পেজ নাম্বার কত পেজ নাম্বার 118 But 118 Ashok Sureka is one of the donor witness. 118 in the part 2 of the paper book, the volume 2. 118. But I'm just pointing out the donor witnesses. Ashok Sureka. This was in what in chief, he stated the second paragraph. I intended to make some gift to Madhusri in her marriage. Mohanlal Parikh said to me that instead of making the gift to Madhusri, I should give the amount in the name of would-be son-in-law to increase his net worth for visa purpose. Mohanlal Parikh said to me that it would be same if I gifted to Sanjay instead of in the name of Madhusri, so I gifted. Then he says that he contributed 62,000 in 2 checks. This Lord Ashok Sureka, the witness number 6. Then in cross-examination, your lordship will see, Lord, the last line. In the affidavit, I did not mention that I intended to make gift to Madhu in her marriage, but on request of Mohanlal, I made the gift in favor of Sanjay in lieu of Madhu. Then, my lord, this portion, my lord, I should also point out, it is fact that I have mentioned in the affidavit that the gifted amount shall be the absolute property of Sanjay Parikh. So this was a cross-examination directed concerning the declaration of, my lord, the donors. The donors had made some declaration affidavit. The cross-examination was directed against, my lord, the contents of the declaration.
But against the documents.
Against a document.
But declaration of gift.
Declaration of gift. So the witness in the chief says that
which will be prevail.
Now, my lord, the witness says, my lord, your lordship will see, my lord, holistically, my lord, the purpose, because this gentleman, being, my lord, the relatives of our side, had no, my lord, occasion to give, my lord, any money, my lord, to the would-be son-in-law, my lord, or the would-be husband of Madhusri, until unless, but they were asked by, my lord, the father, my client's father, to make the gift, and this gift really was intended for, my lord, Madhusri. Because he said in unequivocal term that I wanted to make some gift to Madhusri on a marriage. Although, my lord, for the purpose of a declaration of a gift, it cannot be made, my lord, this cannot be written down. Because the gift is unequivocal. It might be tainted with contingency, but not that I intended to gift somebody else, but I give it to you to be routed through X gentleman or Y gentleman. Then, my lord, again, at page 120, the other witness to this gift. Pastor Pelli. Lord, that is at page 33 to 46, volume 2, part 2. Exhibit 3, exhibit 4,
এই
33, 46 to 46.
এখানে লেখা আছে যে for the absolute you say 35 দেখুন for absolute use and benefit of Sanjay এই জায়গাটা ঢুকিয়েছে একজনই এফিডেভিট করেছে একটা অ্যাডভোকেটি করেছে সব একই কথা লিখে দিয়েছে হ্যাঁ সব আছে
এটা তো অশোক সুরের
to Sanjay Parekh for his absolute use and benefit.
এটা হচ্ছে অশোক সুরেখা মানে যার সাক্ষীটা হয়েছে এই তো
আবার তিনে দেখুন তিনে the amount gifted by me shall buy and shall
remain to
shall be
his
as
absolute property.
his absolute property.
দিয়ে দিয়েছে কবে করেছে এটা দেখো when was this declaration obtained?
Lord, that is what I am trying to find out, Lord.
The date.
ডেটটা ওই ওপরে দেখতো একটা 16 আছে ওটা বুঝতে পারছি।
28 November 1996. The stamp just below the signature of notary public.
28 November, Lord.
So the
Yes, that may be the stamp by the notary.
Yes, yes.
That may be the date of affirmation or declaration.
now the
And the
checks were
date
March-
of gift is 22nd March 1996
March 96
and 28th November 1996.
আর সেটা মনে হয় ক্রিমিনাল প্রসিডিং এ তখন আরম্ভ হয়ে গেছে ক্রিমিনাল প্রসিডিং তখন
Criminal case was started then.
no
My lord,
criminal case was not
criminal
started by
case
that
was
time.
not started then. No, 2001.
2001
2001.
406 2001.
Yes.
Two cases were instituted by the wife.
1996 criminal case এর আগে করেছে
পাটিঘাট
Got together and delivered.
হ্যাঁ
সন্দেহ দেওয়ার রিলেশনশিপটা যে সন্দেহ উদ্রেক করতে পারে এটা হচ্ছে জানতো পরবর্তীকালে যদি গন্ডগোলের টাকাটা এখন বলছি ওটাতে ওদের তরফ থেকে তো দুটো এরকম সাক্ষী নেই যে আমি নিইনি
Saying, Lord, that the engagement was before
1995
1995.
fire from
1997.
Huh?
No, engagement was in 1997. The talks of marriage was not in 1995. 95.
fire from we shall get it.
But that is not the that is evidence is there. In the plaint it is written. In the plaint it is written.
Plaint
It is. It is plaint.
plaint it has been written.
And this is not a disputed position at all.
no that has come in the evidence also
That has come in the evidence.
পাকাপোক্ত কাজ করতো এক্সক্লুসিভলি ওকে দিল কেন
সেটাই
একটা কিছু ঢুকিয়ে দিতে পারতো কিন্তু তাছাড়া আর কি হতে পারে রিজনেবিলিটি তো থাকবে একটা টেন্ডারে টাকাটা একদম চিনি না জানি না তোমাকে টাকাটা কি ব্যবসায় লাগাস কি ব্যবসাতেই লাগাস যদি টাকাটা
Do you want to say anything?
you want to say anything?
If pilot go with the evidence, it will appear that there was no talk of marriage. Initially, there was no talk of marriage in 1985. It appears from the evidence of PW from the plaintiff that the marriage, the talk of marriage started in 1987, not in 1985.
এটাই বলতে
1997 engagement.
Engagement.
Marriage actually took place in
Pilot before the
99.
before the
19
gift, there was no talk of marriage. Before the gift, at the time of gift, there was no talk of marriage.
So you received the money from 11.
we are asking.
Pilot, we said
Out of 11, only one is your friend or relative, maybe.
So thereafter he said that
Uh,
he is also a relative of my client, Mr. Mohanlal Parikh.
Mohanlal
That Prem Sukh Parikh.
10 people without any cause, they came and started making gift to you.
Pilot, there was some condition to obtain the visa from foreign. Some movable,
why will
immovable
people-
property is required.
No,
The
no,
person who is applying, must hold some movable, immovable property.
right. Then why they have given you for utilization for your purpose. Visa will be visa you obtained.
Yes, my lord.
You went abroad.
The proposal of marriage is not October 1995,
Apart
paragraph
from
4.
that, my lord, I have
Yes.
for the expenses. That is not the only that only I took that money and I pursued my study.
No, no,
started
we
my-
are not on that. We are never saying you had sufficient money. But the point is that the money was intended to be gifted to the wife.
Yes.
You are still holding it. The evidence is that it is still there in the Rani Choti's account. All that I was saying that not in the cross objection, we say that this is the money belonging to the wife, intended to be not given to the wife. Therefore, the wife has a right to recover. Any property not given to the wife at the time before or after marriage with an intention to be given to the wife is a stridhan. It cannot be not seen in isolation. They are trying to portray that this amount.
A wife then.
No, Lord, it was not a.
You
Suppose,
are
Lord,
linking
on
you are bringing in an ambience of marriage. Some sort of understanding was
Lord,
there.
let us not. There is no Lord occasion for Lord the people to give, as in the case of Lord engagement ceremony. If there is an engagement ceremony, that is not marriage. The marriage takes place after that. Therefore, as on that date, my lord, on the engagement happens, Lord, technically we cannot call wife, would be wife. But if Lord, any gifts are given at that point of time, then Lord, that is intended to be Lord, to be given to the Lord, the bride. Therefore, here also, Lord, your lordship may consider this is a gift intended for the bride.
Yes.
And in plaint at paragraph 4, Lord, we have categorically stated that is
The character of property that is within the
in October 1995, defendant number 2 came to the plaintiff's father with the proposal of marriage of the plaintiff with his son. I'm sorry.
Just
I apologize.
woman's property depends on the source from which it has been obtained.
সোর্সটা তো দেখতে হবে।
Source তো মানে ওরই রিলেটিভ আরেকজন যেটা সেটাতে ওর সোর্সটা হচ্ছে ওরই পরিবারের লোক যারা টাকাটা ওকে না দিয়ে ওকে দিয়েছে অন আন্ডারটেকিং অন অ্যান আন্ডারস্ট্যান্ডিং যে ওটার ভিসার জন্য দরকার এক্সক্লুসিভ Yes.
Now, my lord, so far as my lord, the content of the, my lord, the documents are concerned, my lord, it speaks for itself. But your lordship will kindly consider, my lord, in the light of, my lord, what the donors have spoken about, my lord, the intention of, my lord, the making of the money as a gift. So declaration was, my lord, a surplusage because that was required, my lord, for the purpose of, my lord, a documentation. That obviously, my lord, for the purpose of documentation, when, my lord, this declaration of gift was done, generally, my lord, at the time of giving a gift, we do not take any receipt, that too in a marriage or an intended marriage ceremony. But when, my lord, a declaration was given, my lord, your lordship may very well, my lord, assume that, my lord, it was given for a purpose, my lord, which needs a recording of, my lord, this particular gift. Without this, he could not have, my lord, shown that his balance has, my lord, risen in the bank for the purpose of showing his net worth before the visa authorities. But he has to show from where he got this money. This is quite a money at that point of time. Therefore, all these people in that declaration given their IT file numbers. And they could not have in this declaration written that it was intended for Madhusri. Then the entire, not the purpose of this declaration would have been frustrated.
Negative argument.
Sufficient fund to go for তাহলে ওর দরকার ছিল না gift এর, that is not-
কিন্তু গিফটটা নিয়েছে এটা তো আমার পয়সা আছে তাও আমি তোর কাছে নিলাম
Anything else, Mr. Mukherjee?
Yes, my lord, there are 2 or 3 my lord, the points my lord, on law. But
yes.
so far as the factual aspect is concerned, my lord, I have covered my lord, on the 2 points, my lord, the ornaments and my lord, the money as a, my lord, a
Money,
gift, which can be treated my lord, as a sridhar. Now, my lord, sorry. Yes, my lord, we have a cross objection on that portion because the learned judge did not allow, my lord, the return of the money.
Yes,
The learned judge allowed, my lord, the return of the ornaments.
yes.
And for that reason, my lord, I say that that should also have been, my lord, included in the degree. And for that reason, it is a cross objection.
Cross objection, yeah.
Ornaments on the schedule, my lord, not on all the ornaments, but my lord, the ornaments which are mentioned in, my lord,
A
two of
and-
the schedules. Yes. I and I, maybe. যেটা দিয়েছে সেটা নিয়ে আমার অ্যাপিল তো নয় ভাই, ওটা নিয়ে ওদের অ্যাপিল।
আবার ফিরে নেবে নাকি?
দে ওই জাজমেন্ট গুলো, তারাগুলো দেখে নিচ্ছি কোনো দাম নেই। কোনো কি বলবো কখন
Next week টা পুরো ছুটি ছুটি
During or after the marriage?
Yes.
Now, let's
Yes.
so far as the money is concerned, your lordship has seen by now, my lord, the evidences that have come. The gift is admitted. The purpose of the gift, your lordship may say what is the purpose, whether it is a Sridhan or it is a an absolute gift. If it is an absolute gift, not the purpose of the gift, not that is there is a cloud, my lord, to find out, my lord, at that point of time why 11 of my relatives or 10 of my relatives would have gifted him the money. If according to my learned friend, my lord, the engagement talks were not there, there was no purpose, my lord, for them to give him money. Because our case is in the plain paragraph 4 is that on October 1995, the talks of not the marriage proposal came. The brother was my client's brother-in-law was working in Lord the same firm where Lord the father-in-law was working, the Parikan Associates.
Yes.
Now, Lord, so far as Lord, my points, Lord, these are my points basically before your lordship. Now, Lord, the other thing, Lord, that has fallen from Mr. Moitro was, Lord,
And the impact of 406 in a suit, that section 43.
section 43 of the Evidence Act. Yes. Now, Lord, your lordship will kindly see, Lord, section 40 to 42, Lord, it is not really not, Lord, is attracted in this. And 43 says that judgment, orders, and degrees other than those mentioned in section 40, 41, and 42 are irrelevant. Unless the existence of such judgment, order, or degree is a fact in issue, or is relevant under some other provisions of this Act. Now, Lord, the question here is, first it says it is irrelevant unless the existence of such judgment, order, or degree is a fact in issue. Therefore, your lordship was trying, or Mr. Moitro was trying to say that the allegation of 406, the portion which dealt with it, is not a relevant fact or a relevant piece of evidence in this particular suit. Now, Lord, your lordship will kindly see, Lord. Oh, your judgment are there? 406, sir. Magistrate. Huh.
Part 263. কোথায় গেল? এই দুইটা? পাটের দুইটা কোথায় গেল? হ্যাঁ, ইয়েরা। ইয়েরা, yes. Page, page.
But kindly come to Lord. Page 63J, that portion of the Lord, the order concerning gift.
Page 53.
63J. J is a type portion, Lord, part 2.
Oh,
the volume 2.
What you are showing?
Lord, the judgment of Lord, the in the 406, the criminal proceeding, because
Yes, 63J.
Lord, kindly see where it states page 25 begins. Now the allegation regarding gift, that 3 lines from Lord, page 25 begins in down below.
Yes.
Then Lord,
Now the allegation.
now the allegation regarding gift
Yes.
of rupees 3.4 lakhs to Sanjay by PW2 through his friend is taken up for consideration as to how much those allegations are true. At this stage, I must make it clear that there is no charge under section 3 and 4 Dowry Prohibition Act. But still, to appreciate the said facts in the totality of the allegation, it is worth mentioning that though PW2 and the other witnesses, such as PW6, PW9, PW10, PW11, and PW12 have stated that they wanted to make gifts in the marriage of Madhusri, and in this regard, PW2 requested these witnesses to make the gift in the name of Sanjay to increase his financial status for the purpose of obtaining visa. But on perusal of the affidavits, when put by the defense, all the witnesses admitted in cross-examination that they made the gifts to Sanjay absolutely. In this regard, another thing should not be lost sight of is the time of making gifts. These monies were gifted to Sanjay prior to 3 years of marriage, and PW2 admitted in cross-examination that the marriage proposal continued for 2 years and the marriage was solemnized in the year 1999. So even if it is assumed that these gifts were made to Sanjay as per request of PW2, still then that has got nothing to do with the instant marriage. Well, this is where, Lord, the portion, Lord, which according to Mr. Moitro says that, Lord, it should be reflected in the, Lord, the judgment of the civil court to be considered. Now, Lord, your Lordship will kindly see the criminal court has not dealt with, Lord, the witness's statement. The witness's statement, Lord, also says about, Lord, the gift being made to Lord Madhusri. I have just read, Lord. But only it says that in the cross-examination, they admitted the cross-examination as I submitted was not directed against the content of a document. All the cross-examination. In the content of a document, when the cross-examination was directed, it was referring to the declaration. And they spoke the truth. They have not contradicted the contents of a declaration.
But how can you say this is not a fact in issue?
This is a fact in issue, but Lord, I am considering, Lord, the relevancy of this fact. This relevancy, whether it is irrelevant or relevant. 40 to 42, Lord, doesn't attract here. But those judgments which do not come under 40 to 42 are not covered under 43. The 43 says it is irrelevant until it is the facts in issue are. The fact in issue is not that I have pointed out as of now before your Lordship. Commonality of the facts in issue. 3.4 lakhs. Therefore, acquittal in a criminal case, that does not ipso facto mean, Lord, that the civil liability is absolved. Because the way your Lordship, Lord, analyzes, Lord, a witness or a, Lord, a deposition in a criminal case varies, Lord, when your Lordship looks at a deposition, Lord, in a civil case. Other, I'm sorry, Lord.
Probability. যেটা explain করছেন সেখানে probability criminal case তো এটা beyond reasonable. Beyond reasonable. তাহলে ওইটাতে যদি এসে থাকে এবং this went up to the Supreme Court.
kindly see, my lord, that if it is, my lord, a criminal code, my lord, absolves a person of a, my lord, a liability, my lord, a criminal liability, that doesn't, my lord, automatically, my lord, in the civil code, my lord, it does not get, my lord, the absolved of the civil liability.
Let us see 406.
My lord, the other thing is that, my lord, your lordship will see, my lord, the reasoning of the learned judge. So even if it is assumed that
We
these
cannot
gifts were
go
made
into
to
that,
Sanjay,
Mr. Mukherjee.
my lord,
It has attained finality up to the Supreme Court.
yes, but that, my lord, doesn't operate as a res judicata, because, my lord, the finding of a criminal court in a 406, but the findings are not.
General principle, but your argument is that kindly consider it from this angle.
Yes.
That what was the document, what is the evidence, and what was the issue on which he was crossed.
Yes.
Taking these three things into consider, you come to a finding.
Yes.
But if we hold also in your favor, how do we distinguish that point? Can we distinguish the criminal aspect only by saying that
I will just try to assist your lordship. My lord, I get your lordship, my lord. My lord, if your lordship endorses, my lord, this view of the learned judge, my lord, to absolve, my lord, which it says the money was gifted to Sanjay prior to 3 years of marriage, and PW2 admitted in cross-examination the marriage proposal continued for 2 years. And the marriage was solemnized in the year 1999. So even if it is assumed that these gifts were made to Sanjay as per request of PW2, still then that has got nothing to do with the instant marriage. But this is the finding of the learned, not the criminal code. Lord, this finding, according to me, Lord, I cannot say, Lord, this finding has been overturned, but that cannot be, Lord, taken to be an absolute finding by a civil court. Because this finding is, Lord, absolutely wrong. That's the reason I wanted your lordship to, Lord, see the purpose. The learned judge has seen, Lord, read the evidence from one angle, from the angle of testing it in the light of 406. But when your lordship is seeing, Lord, your lordship is seeing, Lord, this money given, one, whether the money was intended to be given to the wife, two, and whether the money actually traveled or not, three, and where is the money lying as of now, four. Now, my lord, if your lordship holds that this is intended to be for my client, the bride, in connection with, my lord, the marriage or the intended talks of marriage, it immediately becomes a stridhan.
Then it becomes
A stridhan. This aspect, my lord, is not, my lord, to be seen in that, my lord, perspective by the learned, my lord, the judge in the criminal court, when he was looking at, my lord, from the angle of 406. It might be a relevant fact. The evidence have to be looked into, but it doesn't mean that whatever, my lord, the outcome of a criminal court in this type of matters should be, my lord, blindly followed by a civil court. Your lordship has experience in the disciplinary proceeding matters. Your lordship has seen, Lord, that in many of the cases in disciplinary proceeding matters, Lord, the criminal court, my lord, absolved, acquitted, but in the disciplinary proceeding, Lord, it is held otherwise. Because, my lord, the point of view is different. This 43 comes into play, my lord, when, Lord, the question of admissibility of a judgment comes into, my lord, in a civil court. Why should I admit this particular, my lord, the judgment of the criminal court? I can only, my lord, see this and examine, my lord, the probative value of this judgment if I can show that the facts in issue are common. Otherwise, it cannot be, my lord, looked into. From that aspect of the matter, my lord, it has been seen. But the argument of Mr. Moitra that, my lord, that is the finding of the learned judge has to be, my lord, followed by the civil code in ditto. That is, my lord, not the correct proposition in my respectful submission. But your lordship will see, my lord, the illustrations, my lord, appended to, my lord, section 43. The illustrations in the Evidence Act, my lord, are a great eye-opener for the applicability of the sections. The true purport of not the section 43.
Yes, which is
Your Lordship has.
A, B, C, D, E, F.
A and B separately sue C for a libel which reflects upon each of them. C in each case says that the matter alleged to be libelous is true, and the circumstances are such that it is probably true in each case or in neither. A obtains a decree against C for damages on the ground that C failed to make out his justification. The fact is irrelevant as between B and C. A prosecutes B for adultery with C, A's wife. B denies that C is A's wife, but the court convicts B of adultery. Afterward, C is prosecuted for bigamy in marrying B during A's lifetime. C says that she never was A's wife. The judgment against B is irrelevant as against C. Then, Lord, if A is tried for the murder of B, the fact that B prosecuted A for libel and that A was convicted and sentenced is irrelevant under section 8 as showing the motive for the facts in issue.
Yes.
Lots.
ব্যাপারটা কি বলতে পারে এটা ইয়ে করে মিস্টার
এটা প্যারাগ্রাফ 33 তে বের করে এই আর্টিকেল 2 এর আর্টিকেল ওটা বলেই দিয়েছে।
এটা রিলেভেন্ট কি রিলেভেন্ট এটা অলরেডি তো অ্যাডমিটেড অ্যাজ এভিডেন্স মানে সিভিল কোর্টে তো অ্যাডমিটেড হয়েই গেছে মিস্টার মৈত্র কেন এই দিকে নিয়ে গেলেন প্যারাগ্রাফ 33 হ্যাঁ
volume 2. The key of the said locker.
Parekh surrendered it.
Yes, it says that the key of the said locker was surrendered by Sri Parekh on 25th March 2000. This is for your information. Key.
যা জুডিশিয়াল আবার নিয়েছে চলাকার কোর্ট এবং আমাদের কোর্ট, তাতে ওদের ওই গয়না আর ওই টাকার থেকে বেশি হবে না? যা জুডিশিয়াল আবার নিয়েছে আর যে অ্যাডভোকেটকে ফি দিয়েছে সেগুলো যোগ করলে
Matrimonial suit, my lord, I did not ask for return of the Sridhon article, but this was one of his argument. This was the argument in the context of order to rule 2 also. To which, my lord, I answered, my lord, that having regard to the chronology of filing of the case, my lord, this case, which is before your lordship, was filed in 2001, earlier suit, that the matrimonial suit was in, my lord, 2004. Therefore, my lord, there was no occasion, my lord, for ask for, my lord, multifarious relief or, my lord, a same relief in a subsequent suit. And the mat suit have been decreed, my lord, in 14th of October 2004 itself. And this suit was decreed in 2019. Although it was filed, my lord, in 2001, the decree was in 2019. Therefore, order to rule 2 does not apply at all.
Yes.
Now, my lord, the other argument was the effect of the criminal code as to the ornaments. That your lordship will find, my lord, 63H. I've shown your lordship, my lord, the finding of the criminal code so far as, my lord, the money is concerned, and now, my lord, the ornaments are concerned. Now, my lord, before that, my lord, your lordship will kindly also see 63G about the locker. That is also relevant. 63G, volume 2.
Yes.
Criminal code, when comes to the finding about the locker, were not having, my lord, the evidence of the bank. The evidence of the bank was not there.
This was before the evidence of bank.
But the evidence of the bank most probably came in this particular suit. That was a documentary evidence. Eto এই কথা check করে নে তো। ওটা আমাদের exhibit হয়েছিল।
3A.
3A. তাহলে 3A মানে হলো plaintiff's witness.
PW on the same page, PW 18, Bijoy Kumar is senior branch manager of Vijaya Bank.
That he has deposed.
He said that the locker was opened in the name of Madhusri and Sanjay jointly.
Yes.
But he could not bring the access register.
That I have
so
read on the second day that he deposed. He could not, the bank manager was there, but the 3A is a documentary evidence.
That was not there before the criminal code.
But subject to correction, that was not there. That was exhibited only in this suit.
That is page number.
That
page
29, not part 2.
Hmm.
আর এখানে এসএল বিজয় কুমারটা আগের দিন পড়ছিলাম 139 of part 2.
সেটা এজিটেট করতে হবে, 3টে পড়া মিলে গেছে। Yes. Now, as regards the finding of ornament 3H, what you are saying?
That is 63G and 63H.
Yes.
All that the not this criminal court was of the opinion that I could not produce any not a scrap of paper not concerning procurement of the jewelries.
He stated that silver.
Then Lord kindly come to Lord page 63H, that Lord the first paragraph. The third line, that as per direction of the Honorable Court, articles were produced at Hare Street Police Station where she identified some of her jewelry. But it is not out of place to mention that merely retention of articles does not, page 63H, first paragraph, third line, not from.
She stated that.
As per direction, my lord, your lordship will find, my lord, that first paragraph about, my lord, the last 3 lines here.
Oh, as per direction.
As per direction. Articles were produced at Hare Street Police Station where she identified some of her jewelry. So it is not out of place to mention that merely retention of articles does not call for action for breach of trust. But this is where, my lord, the court is looking from the criminal aspect of the matter. Retention of articles does not come within the definition of breach of trust. So retention is there.
Entrustment.
Entrustment.
The main thing of criminal breach of trust, entrustment.
After she has identified that some of her jewelry,
Entrustment.
then Lord, the interpretation how it looks at it, Lord, does not call for action for breach of trust. It is complete when demand is made but refused. In this case, the jewelry which were left by Madhu willfully were never denied by the accused person. So the offense, if any, is not complete. Regarding misappropriation of money of Madhu earned by her at UK has no legal legs, but I am not on that.
What this fact, where she admitted that out of 10 checks, 9 checks were signed by her for withdrawal of money.
But that is not in the UK, possibly that UK, Lord. There was a case, your lordship will, Lord, I did not place it that way, Lord, that in UK, Lord, they were living at that point of time, Lord, the money that was kept in the account of Madhusri was, Lord, misappropriated by the husband and all this.
Yes.
I did not argue this because of the fact that those cannot be, Lord, termed to be, Lord, it was not a case that those
Subject
money
matter
was,
of the suit.
yes, the Sridhan money was there in the bank. That's the reason I did not, Lord. Barclays Bank in the UK. Because she was working there also and earning money.
Oh.
Then in the middle paragraph where it says page 19 begins, the last 3 lines, why this statement was Madhusri in FIR and statement before police has no plausible explanation. Withholding of a jewelry and silver utensils are afterthought for the purpose of prosecution.
এইখানটা why this statement?
আর কিছু আছে মানে এই দুটো পয়েন্টে এত কিছু ওগুলো ছেড়ে দে। না না এই জাজমেন্টের মধ্যে সুপার অর্নামেন্ট এন্ড দ্য টাকা এক্সপেন্স আর কোনো ফাইন্ডিং নেই যাচ্ছে তুমি যাও Now, my lord, these are only the two findings, my lord, on the 2 points. Then, my lord, there was not an argument on the point that, my lord, there was no proof by my client. And, my lord, it was whose duty to, my lord, prove a particular case. But in this context, my lord, I'll be assisting your lordship by referring to, my lord, a judgment where, my lord, the burden and the onus shifts. But I'll be just, Lord, Mr. Moitra argued that there is no evidence by the plaintiff about the plaint case that she had forwarded. But according to me, Lord, after reading them, Lord, the evidences, Lord, there were 2 witnesses of my client. The 2 witnesses, Lord, categorically, Lord, have not put forwarded the case, Lord, that were contained in the plaint. The moment that has been, Lord, put forward, cross-examined, Lord, the onus shifts, Lord, to the other party. The other party, my lord, had also deposed. There's a deposition in admission of such facts. If there is an admission, my lord, it doesn't come back to my client, my lord, to prove anything further. এটা জোসেফদের কপিটা কোথায় অনিল ঋষিতাতে But I was referring to, Lord, 2006 volume 5 Supreme Court cases 558. But the relevant paragraph is paragraph 19. But this is on the question of, Lord, the distinction between, Lord, the burden of proof and onus of proof.
Para 19.
Para 19. (2006) volume 5 SCC page 555. But paragraph 19 is not the ratio paragraph according to my understanding. The context your lordship will find, my lord, in paragraph 17, and the ratio is, my lord, at paragraph 19. There is another aspect, paragraph 19. There is another aspect of the matter which should be borne in mind. A distinction exists between burden of proof and onus of proof. The right to begin follows onus probandi. It assumes importance in the early stage of a case. The question of onus of proof has greater force. Where the question is, which party is to begin? The burden of proof is used in 3 ways. I, to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later. I, to make that of establishing a proposition as against all the counter evidence. And 3, I, an indiscriminate use in which it may mean either or both of the others. The elementary rule in section 101 is inflexible. In terms of section 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. That's the paragraph. Therefore, in this case, two of the witnesses establishes defendant number one, the father of the husband, comes forward. He does not give any proof to the counter of what my client had stated. Rather, my lord, your lordship has marked the admissions on it. Therefore, my lord, the contention that, my lord, my client has failed to prove the plaint case, but that is not is inapposite in the present case.
Which one you are saying admission?
Lord, so far as, Lord, the locker opening is concerned, so far as the gift is concerned, Lord, there is an admission. The taking of the money. The ornaments taken to the police station is an admission. Total evidence চলে যাবে তো সেটা আমি বলছি না।
Yes.
Then, Lord, this judgment has been relied upon by the trial court also, Lord. This is of some importance concerning, Lord, the Sridhon. Lord, 2016, volume 2, Supreme Court cases, Lord, page 705, 24 to 28. (2016) volume 2 Supreme Court cases 705, 24 to 28.
হ্যাঁ, আমি আমরা এদের যুক্তি করে এসছি আমি মিস্টার মৈত্র
এমন জায়গায় ফেলবো তোমাকে রাস্তা হবে না।
But this is not there in this particular paragraph, Lord, there are, Lord, excerpt from the previous, Lord, judgment which talks about the concept of Sridhar. Although this particular judgment was in the context of, Lord, the Protection of Women from Domestic Violence Act, but the Honorable Supreme Court was, Lord, dealing with the concept of Sridhar.
তো ব্যাখ্যা দিয়েছে।
পড়েছি এটা এই যে ইনফ্রাস্ট্রাকচার বা ডোমেইন ওভার স্ট্রাকচার
Yes, sir. On Thursday.
যে প্রশ্ন প্রশ্নটা ভালো করেনি এটা ভেঙে ফেলতে পারছি
What a reply. No, reply.
Yes.
Then interestingly, your lordship will kindly, my lord, just read paragraph 32. Although I'm not formally citing, but my lord,
Para 32.
para 32. Regard being had to the aforesaid statement of law, we have to see whether retention of Sridhan by the husband or any other family member is a continuing offense or not. Lord, this is from the point of view of Lord 406 and all, but just an interesting topic. That's the reason I see. There can be no dispute that wife can file a suit for realization of the Sridhan, but it does not debar her to lodge a criminal complaint for criminal breach of trust. We must state that there was a situation before 2005 Act came into force. In 2005 Act, the definition of agreed person clearly postulates about the status of any woman who had been subjected to domestic violence, as defined under Section 3 of the said Act. Economic abuse, as it has been defined in Section 3, Roman 4 of the said Act, has a large canvas. Then the last 4 lines of that paragraph. The concept of continuing offense gets attracted from the date of deprivation of Sridhan. For neither the husband nor any other family member can have a right over the Sridhan, and they remain the custodians. আর কিছু আছে? Lord, that is, Lord, so far as res judicata, I have also made my submission, Lord. The res judicata, Lord, the criminal court's finding is never, Lord, a res judicata. The section 11, Lord, it doesn't talk of, Lord, a judgment rendered in a criminal proceeding to be a res judicata. It is all about a suit or a proceeding within 141 of the Civil Procedure Code. That is not where the section 11 is attracted.
That's all.
আর কিছু আছে? নেই তো?
We shall না স্যার ঠিক আছে and we shall give reply on Thursday মালি 11th May.
সবাইকে জেনে নিয়ে আবার
We will took 45 minutes my lord. We will took we shall
I cited only 2 judgments.
2 judgments.
That he says
We
that
shall
it will
not
take 45
we shall not take much more time. Half an hour we can conclude it. If required, my lord, we can supply the written reply.
Whose requirement?
And if it's required, my lord, we can supply written notes of argument.
No. We are not asking you to give any written argument.
Then, my lord, on 11th May, my lord, may be fixed.
Tell us the time also.
My lord,
Yes.
Tell everything, we will fix it on that. Tell us the date, tell us the time, and tell us how long it will take and when we should discontinue hearing it.
my lord, on
Don't make this sort of submissions in court.
into
remember?
কবে আছে কিরকম আছে
তাহলে দেখুন একটা
And has completed his arguments. Stop. This the matter for further consideration. Completed has stopped. Today, comma, an adjournment has been prayed for on behalf of the appellants. Stop. Is the matter for further is the matter the daily supplementary list of this court on কবে বললো 17 বললো on 17th of May as fixed at 2 p.m.
Grateful, my lord. 17th of May.
17th of
May.
Grateful.
नाम लिख दीजिएगा।
এই বইগুলো না উঠে গেলে একটু তুলে দিও তাহলে পড়ে থাকে এখানে
In this matter, I am appearing on behalf of appellant and appellant petitioner. Respondent number 4. 5.
I appear on behalf of respondent 1 to 4, 1, 2, 3, and 4.
And on last occasion, this matter was for orders. And on that date, my landed paid did not come. And someone paid adjournment. And your lordship, department detected some errors or defect. And
what do you want? What you are asking?
Your lordship granted to remove the defect. I went to the department and department few clarification. I gave few clarification, and there is a defect with regard to the cost title. In the writ petition, in the writ petition, Chobirani Chatterjee was respondent number 9.
Yes. He has expired.
She has expired.
That is why you have filed a
Filed a
application.
substitution application.
Have you given copies to them?
Yes, madam.
She expired, but 8 years back. 8 years back. In the meantime, the matter was heard.
And Chobirani Chatterjee died in the year 2015. That was not our knowledge.
What was the order appealed against?
Order dated 21st June 2019.
21st June.
June 2019. 2019, being aggrieved and dissatisfied with the order, I prefer an appeal.
You are who are you? Who is the appellant?
I am the policy holders. This is policy holder's wife.
Wife?
Wife.
To fight between you and your husband's wife?
No, my lord, my mother-in-law, Chobirani Chatterjee, who was implicated as respondent number 9 in the writ petition. She died in the year 2015. That was not our knowledge because I reside at Onda and they reside in Pandapis. When we came to learn that she had expired.
You are Sujata
Chatterjee is that this is policyholder's wife.
Yes.
Wife and sole nominee. He claimed LIC, six LIC policies mature value.
Now, who is Subhash Chatterjee?
Subhash Chatterjee is the son of Chobirani Chatterjee.
Your brother-in-law.
Brother-in-law.
Huh? Your brother-in-law. Now he has expired.
Expired Chobirani Chatterjee, mother-in-law of the appellant.
Chobirani was a party to the writ petition.
Writ petition.
Now you filed the appeal just directly impleading Subhash Chatterjee.
Subhash Chatterjee was in the writ petition.
In the writ petition. So you have deleted the name of Chobi.
Yes, my lord, I did not made her as a party.
Now
And
what
the
is this
department-
application about?
Department suggested me and your lordship granted me leave to remove the defect.
Oh, that is why you have
That
filed
was-
this formal
I was,
application.
For that particular very reason, I have filed the substitution application for implementing the rest legal years of the deceased. They are also
Now you are
beneficiaries.
appearing for whom?
Respondent number 5, Subhash Chatterjee, my lord.
Subhash Chatterjee. And you are for?
Not 1 to 4, 1, 2, 3, and 4. LICI 1, 2, 3, and 4.
So do you want to use opposition to his application for condonation of delay? You are not opposing his prayer. Very good. You are?
This is up to your lordship. I don't oppose.
When did he expire?
20.
Why you did
He
not know?
expired on 23rd May 2015.
Where have you said? What is the dispute?
Lord,
No, this-
they filed the case before the civil court. That's the other heirs of the deceased husband. Now thereafter they moved the writ petition. Chatterjee, in the writ petition, the Honorable Justice Dipankar Datta was pleased to direct the LICI to make all the payments. Now payment was made. Now they filed an application for interest. Now Justice Ravi
File the application.
Ravi Kishan Kapoor was pleased to give the interest rupees 2 lakhs as a whole, 2.5 lakhs. That was paid by the LICI. Now they ask for further interest. That is the in the point in the appeal.
Without assigning any reason.
That is the point in the appeal.
All right. This is the subject matter. Very good. What is your stand?
But I am for respondent number 5, my
So
lord.
if they have received interest, what is your problem? You have nothing to do. Are you opposing his prayer for interest?
He give me a party, my lord. For this reason, I appear, my lord.
No, right. We are asking you, suppose this interest which has already been paid to him,
I have no
are
objection.
you
my lord.
claiming any share from that?
No, my lord, I have no objection.
Very good. Yes. Then you satisfy us on merit that on what ground further interest is required? Justice by the order which has been impugned.
Without
You have
assigning,
By the order which has been impugned, you have been granted 2 lakh interest.
2.5 lakhs.
2.5 lakhs.
2.5
5 lakhs.
So
For
how
the-
much do you want?
For the delay of more than 7 years. Quantum of rupees 14 lakhs. Delayed payment. And another division bench granted me leave to file an application claiming and quantum of amount of the interest pursuant to the reported judgment of Honorable Justice Bhaskar Bhattacharya and Mr. Justice Prabhu Shankar Banerjee. I claim 8% interest. And this petition was heard by your lordship. And after that, your lordship fixed for orders. And on that date, the department detected defect and your lordship granted me leave to remove the defect. Remove the defect is the cost title,
So how much interest do you want?
8%, my lord.
Are, what is the amount? According to your calculation, what is the amount? সরকার ওই জাজমেন্টটা আছে এটার বেসিসে এবার আমাদের
My lord, I have
সাহেব একটা অর্ডার করে দিয়েছিলেন appearance permitted to file an appearance.
I have claimed interest but after calculating.
You have filed that application
Yes, madam.
pursuant to order of 30th March. A coordinate bench of this court granted you liberty to file an appropriate application along with calculation and
Yes,
quantification.
my lord, I have filed. That is can number 2 of 2022. That that application was hard and concluded, my lord.
Your writ petition was decided on affidavits.
Yes, yes.
Yes, yes.
Divided.
Yes. My lord, can number 2 of 2022, page number 10. Page number 10, I have claimed rupees 8,17,663. And out of which 2.5 lakhs already they have paid. Though we did not have approach for compliance the order. After filing the appeal, they sent the 2.5 lakhs through NFT.
Yes, what do you say? How do you how
But that is not payable by us.
how do you come across this judgment?
Not only one thing, not I'm rather than pick up, not all the papers are not with me. I think not only application will be hard. Not kindly take it on Monday. I will argue my point. Or it will take only 15 minutes. Because all the papers are not with me at present.
Already been heard by your lordship.
Sir,
That's long back. Not
Sitting with
September
somebody
22.
else.
September 22.
Your lordship, sir.
September 22.
The respondent 9 you happen to be your mother-in-law.
Mother-in-law.
You,
I want to income.
such a daughter-in-law.
Her legal heirs.
You such a daughter-in-law, you don't know when your mother-in-law has died.
After 8 years.
Huh?
The relation is suspect.
And we have to record the order that one daughter-in-law is ignorant of death of her own mother-in-law. And we have
After
to
8 years.
set aside the abetment. And we have to also award interest.
Side is the far away, my lord, is the Hon'ble.
So you are not.
There is no relation.
Why you were divorced?
No, after
No,
the
happens
demise
to-
of the of her
Your
husband, she left the heart.
you have no moral duty to keep in touch with your mother-in-law.
They also in-laws members also also.
Where have you
misbehaved.
stated that not residing ID? Where is your averment that you did not know this fact for 9 years? It is not a matter of course. You have
No,
to
my lord.
satisfy us.
My lord, my lord, I have filed a substitution application in the trial court, but trial court did not give any.
Where have you
importance.
stated that you have filed an application for substitution before the trial court?
নজরই আনেনি নাহলে কেউ তাই না
বলেও নি।
বলেও
He died in 2013, 15,
15, my
and
lord.
you came to know in 2019, after
19.
4 years.
হ্যাঁ
Legal certificate, same on every Yellow.
একটু পেয়েছে আবার একটু পেয়েছে তো
Actually, near about 13 lakhs.
Near about 13 lakhs.
13 lakhs.
13.
As per their allegation, it was withheld for how many years?
More than 7
7 years, but
More than
the fact
7 years.
remains
Without
that
any-
we are not responsible at all because it was pending in the trial court. They fought in the trial court for last 7 years.
LIC
Thereafter, they filed the writ petition, and the Honorable Justice Dipankar Datta was pleased to pass this order, and we paid then and there 13 lakhs. So
There was no stay.
There was no stay
no
in this.
stay, not there
No,
was.
but
Sir,
not-
wait.
Wait.
but
There was no stay.
no stay, but how can we pay? Because 2 years, two years of Chovidani,
We're fighting.
they wrote to us, they wrote to us, don't pay, because we are also the owner. We have to get that money also. Please don't pay her.
Who said?
Yes, in the trial court, Hooghly, in the succession case, that two brothers-in-law, they filed
That
application.
you have stated in your opposition. to
Yes.
the
Yes.
petition. All right.
My lord, LIC was not implemented as a party in
Yes.
the lower court. Neither there was no injunction.
That is your fault.
Restraining
That is not
order.
my fault.
We will hear you.
In spite of that, LIC withheld the money without any reason.
এইটাতে শোনো
There
তো,
was obvious reasons.
এই রিট পিটিশনটা কল
The letter was wrote to us.
এই রিট পিটিশনটা রিকুইজিশন কর। WP number 956 of 2012. No. Why it is 1471?
1471.
Then what is 956?
First time we filed this in the original side.
Oh, I see.
Thereafter, like the Honorable Justice Dipankar Datta given liberty to convert the matter in the appellate side.
আমরা আবার এখানে কখন নিয়ে দিলাম লিভ দিয়েছি বলছে 25/11/2022 এগুলো কেটে দেওয়ার জন্য 25/11/2022 আমরা লিভ দিয়েছিলাম স্টেট ব্যাংকে বাদ দিয়ে দিতে স্টেট ব্যাংক অফ ইন্ডিয়া
We passed any order on
25/11
25th November?
Your Lordship had the matter on a can 2 of 2022 and posted for orders. And on that date, your Lordship granted leave to defect, to remove the defect.
So who gave you leave to struck off State Bank? You have just cancelled.
Honorable Justice Dipankar Datta told us to expunge those names.
But then why you have written that leave was granted by us on 25th November? How could you do it without our order?
আছে কি সেইটা
I went to the department. After obtaining the leave of your Lordship, I went to the
Wait.
27 আমরা দিয়েছি লিবার্টি টু রিমুভ দ্য ডিফেক্ট
কেটে চলে এসেছে।
ওইদিকে কেটে চলে দিয়েছে
এক্সপান্স করেছে বলছে।
আমাদের অর্ডার
ছেলে রেকর্ডে ছিল ওই বলে টেক ডাউন
Can 3 and can 4 of 2023. Acha, this application, can 3 has been filed for setting aside of the abatement of this appeal. Acha. In respect of respondent number 9 and can 4 of 2023 has been filed for condonation of delay for setting aside to such abatement. So, Mr. Natasha Lanet advocate appearing for the appellant applicant submits that respondent 9, number 9 of the writ petition
Petition.
in the appeal.
In the appeal, she was
Abhi
not
baat hi
made
nahi
as
baat.
party.
Eh?
In the appeal, she was not made as a party. Therefore, department detected the defect. That two cost title, the writ cost title and the appeal cost title is not matching.
তার মানে এখন
For
বসে
that
writ
particular
petition এর
petition, they have suggested to file substitution application.
সেটা কি করে কি হবে?
মানে যদি আমরা বেনিফিট দেবো তখন এটা করে দিই
ছেড়ে দিন, হ্যাঁ।
তুমি এই রিট পিটিশনটাকে রিকুইজিশন করো। There are affidavits filed in the writ petition.
Yes.
হ্যাঁ, এইটাতে তো সুভাষ তো পার্টি ছিল। রিট পিটিশনে পেন্ডিং থাকা অবস্থায় মরে গেছে।
মরে গেছে, এই অ্যাপিলে পার্টি করেনি।
অ্যাপিলে শুধু সুভাষকে নিয়ে আসছে, পার্টি
আর পার্টি করে। সে ডিফেক্ট
আর রেকটিফাই তো করতে।
রেকটিফাই মানে তার মানে ওকে পার্টি করতে হবে, করে আবার সাবস্টিটিউট করতে হবে।
8%।
হ্যাঁ,
ওকে আর কি করে পার্টি
সেইটাই।
অ্যালাউ তো করতে। তো ঠিক আছে, আমরা মেরিটটা দেখে নিই, যদি রিট পিটিশন যদি মনে হয় যে আমরা করব।
হ্যাঁ, তাই হতে পারে যে পেন্ডেন্সি অফ দ্য যে কোনো স্টে নেই, সুতরাং তুমি কেন দেবে? উইথল করেছো মানে এটা পয়সা দাও, এই কারণে দিয়ে
হাসপাতাল
Number 1471
নিয়ে নাও। of 2013।
2013.
আচ্ছা, ওই ফাইলটা রিট পিটিশন নাম্বারটা কল করো, করে মানডে উইক রেখে দিও।
My lord, not in Monday, my lord, keep it on 10th, my lord. When
Then we are keeping after vacation.
no, my lord.
after vacation.
10th, my lord, 10th.
We are keeping Monday week.
We have waited, most probably you are suffering from any illness or anything, eh?
All right.
You was adjourned on your gown. On several occasions. Come after vacation.
No, my lord.
Try your luck after vacation.
You have got the money, you have got interest of
Insufficient interest.
Not insufficient
2.5
at all.
lakhs.
Where LIC enjoyed 13%
What? Why?
compound interest.
How? Can you show any document?
Before vacation, যাদের agency আছে।
Yes, next.
My lord, on behalf of the appellant, I am praying for not today.
What is the matter about?
My lord, I am the writ petitioner, my lord. My lord, I applied for a loan in 1996, house building loan from FCI. That is my employer, my lord. I repaid the loan during my service tenure, and some interest was unpaid. That has been deducted from my gratuity. But the title deed, which was mortgaged, till now has not been returned to me. I expired. My writ petition was preferred by my legal heirs of the employee. My lord, I obtained an order from the honorable single judge, my lord.
What did the court say?
The court said they have to return me the title deeds, my lord.
No, that is a title deed executed by the employee concerned.
Yes.
You were an employee of, you are
FCI.
still alive.
No, when I took the loan in 1996, thereafter, my lord, I retired on 31st of May 2011. Before my retirement, I paid off the principal amount of the loan, house building loan. But some interest was yet to be disbursed by me, to be repaid by me. My lord, that interest amount has been adjusted from my retirement benefit, my gratuity.
You challenged that.
No, they took my the interest, but
Alright.
they didn't give me the title deeds. The title
Why?
deeds.
What is their
They
stand?
say that there is a order, a punishment order, minor penalty, wherein they will get they were to recover an amount of 3,15,000 from my terminal dues. That they have not done. So they are upholding my title deed. But title deed is in respect to the loan only.
That cannot be done.
That is the issue, my lord.
Now, there was a punishment against you.
2 minor penalties issued in 2011. And I retired.
Let us understand.
Right.
When did you take the loan?
96.
96 you took the loan.
My lord.
You repaid the same when?
My lord, before my retirement, that is pleaded by them only in the stay petition. During my tenure of service, I repaid the principal amount.
I see.
But
now presently, what is the scenario? You are
the employee is dead. The employee has expired.
Employee expired.
My lord.
You have brought in his heirs.
The writ petition was filed by the heirs only.
Oh, I see. I see.
With the prayer to reimburse to give.
So the ground for withholding of the deed is that you have not complied with prior orders of punishment during your service tenure. This is the ground.
Yes, that the order was that this amount of minor penalty which was to be recovered from me will be recovered from the employee's service benefits, the terminal benefits. They didn't recover that. They paid my terminal dues. Only the interest on the loan has been recovered.
Canter nahi hai ghar. Come tomorrow. Canter hai na? ঠিক আছে কাম after vacation করে দাও একে ডেকে দাও
কারণ হচ্ছে আইনগত অফিস থেকে
No. After vacation. Yes, ওটা লিখে নিয়েছো? After vacation লিখে নিয়েছো? Okay, কি better আছে?